for blatant errors. And
well, give me some of the other.
Give
me something else.
Judge, with regards to Mr. Phillips' medical treatment, particularly on page, or here, Mr. Phillips did report to receiving government assistance in the page that's titled Financial Obligations, Assets, and Debts. Government assistance, none reported. Amount, none reported. Judge, with regards to the physical health, in the current medical condition section, there's a narrative that alludes to a MVA, motor vehicle accident, bleeding, spleen, broken back. But then right underneath it, treatment, prescribed medications, none reported. Physician, none reported. And Mr. Phillips
who did this? Who did this report?
I think Mr. Gregory Cooper did it, and I think he's no longer employed with probation.
Okay. Well, I'll tell you what I want you to do, counsel. You write up any objections or exceptions you have to this, submit it to probation. Who's going to be handling this in the future over there?
I don't know. It's like playing roulette in Clinton County. It's going to be there, so I'll just contact the office. They don't know. We hadn't got a response.
Okay, well, you just put your exceptions. Is there anything that would affect him being sentenced? So you want to delay the sentencing is what you're telling me?
Judge, we can note that for the record.
I don't want to note anything for the record and have an appealable issue. I want you to tell me whether or not you think that there's a substantial difference that should affect sentencing. If there is, I'm going to give you an opportunity to submit corrections on this, and we'll give it back to another probation parole officer to do another pre-sentence investigation. Okay, thank you very much.
Judge, we will go ahead with sentencing.
No, I'm not going to go ahead with sentencing. I just think there are too many problems here. You know, I have no confidence in it. What was he?
Judge, with the errors or omissions, nor do I, but that's.
Well, I want you to step away and talk to him about it. I just want to make sure he understands what we're dealing with here. And I just, you know, okay, and I'll call the case back. Yeah. Commonwealth of Kentucky versus Thomas O'Donnell, 22 CR 00103. He has not been transported here. Yeah, is he down there? Why don't you call the jailer and see if he's been transported yet? Could be transported. There was a 10 o'clock. $10:30 for detention center people. So we'll find out where he is. He's being transported.
Judge, my apologies to delay the court. We can recall Mr. Phillips' case, and Judge will agree to submit the exceptions.
Well, I'm gonna make sure that he understands that this should be modified, because once one of these things is done, it follows you through your travels through the Department of Corrections, and it could be very well something that would affect your eligibility for something. Okay.
Thank you, Your Honor.
Okay.
Have Your Honor, or any way that I can go back and sign it 3 for 5, please?
Let's see here where we are.
Daddy. My grandmother's
Wait just a second. What's the Commonwealth have to say? Y'all want to move to the left? This was a first degree, first offense, methamphetamine, fleeing or evading police officers and resisting.
I'll say something first on behalf of Mr. Phillips. I'll say the other case, it appears where he's been charged with receiving stolen property.
and things of that matter that's still pending, I'll be moving to dismiss because I'm getting no cooperation from the victim in that case.
Okay.
Now, in this case, the Commonwealth's recommending a sentence of 3 years based on the fact of Mr. Phillips' extensive criminal history. He's had multiple felonies. He's had multiple felonies amended down in district court. I don't know that he's ever had a job of any time since he lived in Clinton County. All I know he's done is he's participated in thefts and used drugs. So I'm recommending a 3-year sentence.
I noticed on this pre-sentence investigation report, it has 1 to 5 on there, and that's not correct.
That's not correct.
That's another thing that's not correct. Okay. Yeah, what would you have like to state on behalf?
Judge, with regards to the statute, the presumption is probation. Mr. Phillips on the PSI, I mean, if we're taking it at face value, does score a 3 out of 8 on criminal history, criminal activity, which is
Well,
low.
I find that how many years
Let him finish. I'll
Okay.
give you a chance to respond.
So Judge, I know we have this PSI, and we can't take it at face value, but if we're looking at that portion, criminal activity is a significantly low score, 3 out of 8. And Judge, it's a statute is presumptive probation. If we're looking at what Mr. Phillips actually entered a naked plea to, which wasn't a plea and obeying felony, plea and obeying misdemeanor charges, and there wasn't a PSO. But that's indicated in PSI. So good, it's
Okay, you want to respond now?
Yes, first of all, there's no PFO in this case because the legislature in House Bill 461 amended the law that you can't PF a possession of controlled substance. So first of all, that's the reason there's no PFO. It's not because he doesn't have previous felonies, he's not eligible. Now, if you just look at Mr. Phillips' criminal history, he's got a 28 case criminal history. And just going back to the felonies, in 21 CR 17 in Clinton County, he had a possession of controlled substance first degree. It was amended down to a misdemeanor 12 months. Then 22 394, driving with no insurance, 18M 320, possession of marijuana, 18M 73, shoplifting, 17F3, criminal mischief first degree, amended down to criminal mischief second degree. 16 CR 82, burglary third degree, had a sentence of 2 years. 14 CR 20, theft by unlawful taking, 5 years. I could go on, but
I have it in front of me.
so I understand there's presumptive probation, but the legislature hasn't taken all the court's discretion away. And if that doesn't overcome a presumption for probation, I don't know what does.
Well, a very extensive criminal history. Plus, quite frankly, Mr. Phillips kind of jacked the court around. He said he was going to enter a plea, he wasn't going to enter a plea, then he had all the jury over there, So, I'm going to sentence him to 3 years. And on the fleeing and evading, I'm going to give him 12 months. Of course, 12 months will run to 3 years. And on resisting arrest, I'm going to give him 12 months. And I'm waiving the fines on both of them and do 1 court cost. And he can pay that when he gets out. What's the normal court cost here?
Probably around.
Well, I'll just make it 200. It's usually more than over there. And he can start paying it 30 days when he gets out. So he's in the custody of jail. Thank you very much. Then let's go into out of custody. Curtis Adams. Commonwealth of Kentucky versus Curtis Adams, 22 CR 00107. What's the story on this, Mr.?
Your Honor, all I know is if we can get Miss O'Shea on the line, she's asked for a revocation based on the fact he wasn't reported. That's all I know.
Okay, you want to call your first witness?
Yeah, I think it's Jennifer Oshevsky. I think if I'm pronouncing it correctly.
Ms. Oshevsky, you raise your right hand. Swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth.
Yes, sir.
Proceed.
Ms. Olszewski, have you been supervising Mr. Curtis Adams?
Yes, sir.
And when did that begin?
His supervision started. Give me 1 second.
We either turn the volume up or something. I can't hear it.
You have to speak up, man.
The volume's not even on. That's not, I think.
Hold on, let me see if I can. Is that a little bit better?
Just speak up.
Okay, so I started supervising him in, I'm trying to look real quick.
Okay, let me tell you something. We're calling you up on a case here and you look like you're not familiar. Did you do any preparation for this whatsoever?
I started supervising him in July.
Okay. What is the problems you've had as recently as regards to supervision?
Well, I went and done a home visit on him because we do home visits to verify addresses. And he was not there. I had talked to his mother. His mother said that he had been gone about 2 days with his girlfriend in another county because the girlfriend's mother was sick. So I let her know that was something that he had.
Okay, I don't want to start once upon a time and tell the whole story. He was not reported. Is that correct?
Let me ask you this, Miss. What day was he supposed to report?
He reported on 8/1.
Okay.
But when I went out on the home visit on 8/3, he was not there. So he was out of county and he had absconded because he was not living at that address.
So that's the violation, is that he wasn't living where he's supposed to and he wasn't staying in the jurisdiction he was supposed to.
Correct. I did not know where his whereabouts was. He absconded. He had more than one address.
Okay. When's his next report date?
His next report day is on 9/5.
Okay. Has he missed any appointments?
No, he has not, but he's been out of area for some time, so he's not in my area to be able to be supervised, sir.
Okay. My last question was he supposed to attend life skills and has he done so?
No, he has not. He has failed to attend treatment.
And that was after he was assessed with SSC?
Yes, he was supposed to go to life skills. I called life skills and they said that he tried to do another appointment and he never showed up to that appointment either.
Okay, thank you. That's all I have.
You're welcome.
You want to inquire?
Yes, Your Honor.
Speak up. You have to speak up.
Yes, sir. Ms. Olszewski, so he reported in August 1st, and then you're saying you did a home visit August 3rd at 2503 Noah Bledsoe Road, Smith Grove, Kentucky, and he wasn't there, correct?
No, he wasn't. His mother said that him and his girlfriend left. They was just now moving in. The kids was already registered for school there, but they had left because the girlfriend's mother was sick.
Okay. And when he reported in August 1st, he left a phone number on that report-in sheet, correct?
Yes.
And how many times did you call him?
When I done the home visit, I found out that, he wasn't there. He'd been gone for a couple of days. And I tried to call him a couple of times, couldn't get a hold of him. So I called his mom again on 8/10. She said that he was still gone and he was working in the other county.
Okay. And did you ever verify his employment or check with his employer?
What appointment?
When he came in to see you August 1st, after that, did you ever verify his employment or talk to his employer?
He said he was working in Bowling Green and he was switching jobs.
Okay. Did you verify his employment?
No, sir.
Answer.
Okay, so no, you did not. Now, when you're saying that you spoke to his mother and that you called his mother, but you're saying you called him twice?
Yes, I called him with no answer. So I
Okay.
called his mother back to see if he had came back home.
Okay, and then you filed this motion to revoke.
Yes, he had been gone for 10 days or more from the address that in the supervising district that he was supposed to be supervised in. He was in a whole total different district.
Okay, what district do you believe he was in?
I do not recall what county she said that he was in, but he was not in Emerson County where he was said that he was and where he's supposed to have been living at that time.
I would think that part of your job is being a records keeper, correct?
I mean, whenever we do stuff, yes.
Okay, so when she told you that he was living in another county, you didn't write it down?
I'd already done absconding when I had talked to him and he said he was gone.
I have no other questions, Your Honor.
What's Cumberland have to say?
Your Honor, we have two witnesses.
Your Honor, even though Mr. Adams has not cooperated with the officer, he's been out of the jurisdiction, he's not went to his drug treatment. I think under the standard, it'd be hard to revoke him at this time, but definitely he's not compliant. So I think there should be some.
It wouldn't be hard to revoke him. All I gotta say is he's revoked.
Yeah, I mean,
But I'm gonna let them have some witnesses, brief witnesses.
Yes, Your Honor.
Call one.
Your Honor, I would call his mother, Mrs. Adams.
She take a stand over here.
No, in the seat.
Oh, right there.
Bailiff, show her where to sit there.
There. So it's still there.
Just lean toward that red light there, state your name. Sit down. See.
My name is Debbie Dyer Adams.
Okay, go ahead.
Okay. Miss Adams, do you remember this probation officer coming to your house?
Yes, sir. She showed up with her hand on her gun.
Okay. And where did you tell her that Mr. Adams was at?
I told her he was at work.
Okay.
His girlfriend and the kids were away visiting her mom here in Berks.
Okay. All right. And where does he work?
He works at AutoZone.
Okay. In Bowling Green?
Yes,
Okay. And did you let him know that she had come by the house?
I let him know, but she told me he didn't have to call. She would be back.
Okay. And did she ever come back to your house?
No, sir.
Okay. And did she call you later?
Yes, sir. She did.
Okay. And what did you tell her then?
I told her he was at work. It was during the day. Most
Okay.
people go to work during the day.
Okay. And had you not seen him for a few days?
Well, not seeing him is different with us. He gets up and leaves before I get up.
Okay.
And then when he comes home, I'm at work. I'm a realtor, so my day is from 5, till whenever
Okay.
that night.
Okay. And so has he been living anywhere else besides your home?
No, sir. He lives at that. I invited her to come into the house to see where they live, to see mail. She said, no, I don't need to. I'll be back.
Okay. Okay. And are his children enrolled in school using your address?
Yes, sir.
Okay. I have no other questions, Your Honor.
You have any inquiry?
So it's your testimony under oath that she told you, heard him not to call her.
Yes, sir. She said, I will be back. Now, the Thursday when she called, she did say, have him call me or I'm going to revoke you.
Okay. Did you tell
I
her?
text him and he called her. But
How
she
do you know he
said,
called?
well,
Because
he
you
told
never
me.
saw him. I'm just curious.
No, he told me and I believe him. He's my son.
Well, I
and
understand
believe him.
that. I wish my mother was still around to take up for me too, but I understand that you're taking up for him, but you didn't see him call her.
No, he was at work. How was I going to see him call her?
Okay. Oh, no.
Is there anything else? You may step in, man.
Thank you.
Do you have anybody else?
I'm going to call my client as witness, Your Honor.
Okay, go ahead.
See it over there.
You'll raise your right hand. You swear to testimony that's gives the truth, the whole truth, and nothing but the truth.
Yes, I do, Your Honor.
You may proceed.
Okay, Mr. Adams, are your children enrolled in the South Edmondson Elementary School?
Yes, sir. My son Cameron Adams is enrolled second grade, and I also have my nephew at the moment, Kenyon Alexander, staying with us, and he's enrolled
And
there
that's-
too.
And that's using the address at 2503 Noah Bledsoe Road, Smiths Grove.
Yep, 42171.
Okay, and you received a postcard from the school
That
with his
was,
name on it saying that school's getting ready to start? and
yes,
they're gonna-
that was for the open house that they had on, I guess it was the first day of school was the 22nd, open house was the 16th
Okay,
or something like it, yeah. So,
okay. And at any time since you reported in August 1st, has your address changed?
no, sir, it has not.
But have you lived anywhere else since August 1st?
No, sir, I have not.
When is your next report date?
9/5 at 1:45. And I asked her deliberately, I called her and talked to her after my mother had talked to me. And when I talked to her, she was like, well, she just said, because what my mother said was, she's going to have to violate you if you don't get a hold of her. I immediately called her. And then when I called her, she said, you can just take it up with the court system because I've hit you with absconding and whatever else she might have said. And then I was like, well, how have I absconded? I just seen you on the first, passed my drug test and everything.
Okay. And as far as reporting or having a appointment with Life Skills, do you have an appointment with scheduled with Life Skills?
September the 6th at 1 a.m. They're months out. 1 p.m. Yeah. Whenever I missed whenever I had to reschedule the first Life Skills appointment or however it went, I had court down here. Is the reason why I didn't do the assessment down here. That's the only reason why I come down here, because I had court in district court down here.
Okay. And so you intend to go to that appointment September 5th with Life Skills, correct?
Yes, sir.
And that's the first time that they can get you in?
That's the closest, that's the quickest they can get me in. They had called me and left in a voicemail, which was just blank, and it didn't say nothing on there or nothing. So I didn't know about this next appointment they get scheduled for me. So that's the reason why I missed that appointment.
Okay. And did you text her and ask her what you need to do? Or
Yeah, I've called her. I called her personal number because I called the office first and they gave me her personal number. I called her and both her work phones. I guess it's two. I've called her on 3 different numbers and she will not call me back. She has not tried to get in contact with me since the day I talked to her, which was Thursday, August 10th, I think. And all she told me was, I asked her, would I have a warrant for me and how I needed to resolve it? Do I need to come into the office to see you? How do you want me to go about this? She said, I guess you need to call Cumberland County Sheriff's Department and see if you got a warrant. And basically that was about all she said and basically hung up on me.
Okay. And can you show us where you texted her?
Yeah, I can show you that. My phone records for this month right here won't come out to next month, but I can get them to where I've called her 3 or 4 times. She's not returning the call.
Or that shade over there too. Goes away. So it's 2, 3, 3.
Now approach her. So when you text her on August 10th, she didn't text back.
No, I mean, I've not heard back from her since the day that Thursday when I called her. She basically I've been compliant with her. I went and sent her on the first. If I'm
Officer, what is it that you want this young man to do to be compliant with the obligations he has? Could you give us a list of things?
Sir, I mean, if he will just, come in on 9/5 and make sure that he's at that address and not going and staying at other addresses for 10 or more
When do you want him to come in?
9/5, that was his reporting day.
September 5th.
Yes, sir.
And what information should he bring to you on September 5th? He's employed, so he'll bring you proof of employment.
Yes,
And
I
then-
need proof of employment. I need to know, I need proof that, he set that appointment for, life skills.
Yeah, he'll give you written,
I got it.
And if he needs to go out of town and he knows this, I will work with him and give him a travel permit. I've
Okay.
told him that before. We've talked about that.
Okay, well, I'm gonna have him there. I'm gonna withdraw the bench, the warrant we have. I'm gonna withdraw the warrant. Mr. Adams, you're to be there on the date in September that you're scheduled and have written proof of your appointment with life skills.
Yes, yes, sir.
Okay, you're also to have written proof of your employment. Now, you understand that there's been some friction here
Yes, sir.
in this thing, and you need to take that into consideration and try to be compliant.
Yes,
Because
sir.
if you come back over here the next time, it will not go well if you're not compliant.
Yes, sir.
Okay,
Can we clarify one thing, Your Honor?
well, you look like you're in pretty good shape right now. He's leaving here. Go ahead and clarify something. Maybe I'll change my mind.
Well, so he lives in Edmonson County, correct? Ms. Olszewski?
Yes,
Okay, and he works in Bowling Green, so does he need a travel permit to go to work?
we've
Or
already
where's-
discussed it. We've already discussed that, sir. We went over the general conditions and his designated area to stay is Edmonson County. But I also told him, and he knows this, that he can work in Bowling Green, he can shop in Bowling Green, he can go eat in Bowling Green. And I told him, as long as you lay your head in Edmonson County every night, that's Edmonson County. I understand that Edmonson County don't have a lot of jobs.
Okay, thank you very much. Thank you, officer, for your cooperation. You're excused.
Thank you.
Okay, Tiffany Bell.
Thank you, Your Honor.
Okay. If she doesn't give, you tell her that if she doesn't file proof that she has COVID, then she's going to jail, okay? David Brinker. David Brinker.
I just want to make sure you got the right warrants that you made revoke this, start on one.
What?
Probation violation.
Yeah, I pulled that.
Okay, I just want to make sure.
Yeah, okay, he's fine. He's good. David Brinker on an arraignment, active warrant out. You want to? Jeremy Curtis. Sentencing, Jeremy Curtis. Are you Jeremy Curtis?
Yes, sir.
Were you born in 1979? Last four digits of your social security number 6097.
Yes, sir.
Here today for the purpose of sentencing. Have you had an opportunity to look at the pre-sentence investigation report done by probation and parole?
And Judge, got this first time I have met Mr. Curtis. I don't have a file form and I don't have a PSI either.
Who was his counsel at when he entered his plea?
And I guess, Judge, just to know, there was a transition where my firm received DPA files about 2.5 weeks ago. And Mr. Curtis is telling me that he's been accepted into the drug court.
He's been sentenced.
Judge Wood, we can waive pre-sentencing.
No, you can't. Here's a copy of this. You have a bailiff. You have anybody with you here today, counsel, or are you by yourself?
I'm by myself, Judge.
Here's a copy of pre-sentence investigation report right there. You can take him out and review it. Brett Davis. Come up versus Brett Davis.
Morning, Your Honor.
Hello. This is 23 CR 0028, Commonwealth of Kentucky versus Brett Davis. Are you Brett Davis?
Yes, sir, Your Honor.
You born in 1994?
Yes, sir.
Last four digits, social security number 2736.
Yes, sir, Your Honor.
You're here today on pretrial conference. What's the Commonwealth have to say?
Mr. Cross.
You come up behind the podium.
Mr. Cross,
Request one more pretrial. I've made my position clear in this case. If he can be at the pretrial with his client, I will go along with that and have a motion days October the 4th or 5th. I know the negotiation day, September 29th.
29.
Yes.
And Your Honor, let me say, this is a case where it's going to involve restitution, and we're making progress on it. We're just going to have to come up with a whole lot of money.
When is the negotiation?
Following Thursday, October the 5th.
Negotiation September 29th.
We're saying 29th at 9 o'clock.
That's correct.
We can do that.
This is wrong here. October what? October 5th. Okay. 29th and the 5th. Okay, thank you very much. Commonwealth versus Salisi Davis, is that correct? There's an action for it. Aiden Fields. Aiden Fields. Commonwealth of Kentucky versus Aiden Fields, 23 CR 0051. Sir, are you Aiden Fields?
Yes,
Were you born in 1977?
Yes.
Last four digits of your social security number are 0320.
Yes.
You're here for a pretrial conference. Says he's represented by the Department of Public Advocacy.
That would be Mr. Pennington. Sorry, we moved cases over. I can go about it. Oh, here.
It's Commonwealth versus Aiden Fields. Mr. Fields already acknowledged he's born in 1977. Last four digits, social security number 0320.
Yes.
What's your current address, Mr. Fields?
109 Allen Street.
109 Allen Street, Burkesville, Kentucky.
No, Albany.
Albany, Kentucky. 109 Allen Street, Albany, Kentucky. We're here for a pretrial conference. What do you have?
Judge, we negotiated this case a couple of Fridays ago. If we could get another negotiation date, I actually just received some additional evidence in Mr.
What
Fields'
kind of
case.
case is this? What did you offer? Come up to the microphone. Yeah, I know.
Yeah, it was 3 years, pretrial diverted for 5 years, supervised. I thought there was a conflict. Is there a conflict between him and the co-defendant, or is there gonna be conflict counseling?
We just received evidence that we don't know if there's going to be, if this is going to be treated as a co-defendant case or it's going to be two separate cases because there was a passenger, Mr. Purdue, who's also on for pretrial.
Yeah, his would be a probated offer because he's a convicted felon. So,
Mr. Purdue, you're talking about?
yes.
There's an issue on the drugs, on who admitted to what belonging to whom, and
Well, that's novel. Nobody wanted to claim the drugs, you know. What do you want to do, Mr. Stockton?
Well, if Mr. Pennington's gonna represent both of them, he needs to file a waiver. If he's not, then they need to be both parties need to be at the negotiation day with counsel and a pretrial on October the 5th, and I'll set a trial date if they want to proceed in that fashion.
that's fine.
October 5th, be there. September the 29th at 9 a.m.
pleas.
at 9 a.m. here. Both of them are conditions of your bond. You shall notify the Commonwealth at least 10 days before the 9th. We're going to represent both of them. And one or the other of them shall have conflict counsel there with them that day on September the 29th. And everybody will be back here on the 5th. Donna Firkin.
Thank you, Judge.
Yeah, Donna Firkin. Commonwealth versus Donna Firkin, 23 CR 0015, here for the purpose of sentencing. Are you Donna Firkin?
Yes.
Born in 1973.
Yes.
Last four digits, social security number is 6727.
Yes.
You're here today for the purpose of sentencing. Have you looked at the pre-sentence investigation report done by probation parole?
Yeah, I did. I think there's a couple of things that needs changing on there.
Okay, tell me what they are.
Larry Harden, he's not my uncle. He's just a friend.
Okay,
And I think misspelled Brenda, my sister's name, Brenda Nance. That's, her name is Nance. I think it had Nancy on it. Rather than that, that's all I see.
okay. Is there any reason why this lady should not be sentenced today?
No, Your Honor.
On a plea of guilty possession of controlled substance, first degree, defendant shall receive a sentence of 3 years, probated for 5 years. Probation is to be supervised. On plea of guilty to failure to maintain insurance on a motor vehicle, the defendant shall pay a fine of $500 plus court costs. On plea of guilty, operating motor vehicle with alcohol concentration above 0.08 or while under the influence of some substance, she shall pay a fine of $200. Now, when you enter these pleas, you were told that this was a felony plea to be used against you in the future. You were also informed, am I correct, that this DUI could be enhanced if you got a new DUI. Is that correct?
Yes.
Okay. What are the total costs? $1,400. Would you need some time to pay that?
Yes.
I'll let you pay it $50 a month. First payment being done 30 days from the day you should meet with probation parole officer right there on your way out. Okay?
All right, thank you.
Thank you very much. Ernest Gates. Come up with Ernest Gates. Commonwealth of Kentucky versus Ernest Gates, 23 CR 0062. Are you Ernest Gates?
Yes, Your Honor.
Born in 1971.
Yes,
Last four digits of social security number 7259.
correct.
You're here on a pre-trial conference. What does the Commonwealth have to say? Mr. Stockton, you will come up to the podium.
There's supposed to be a plea, Your Honor.
Yes, sir.
It's a version plea. Motion has been tendered. I understand, sir, that says you wish to enter a plea today. Is that correct?
That is
Are
correct.
you currently under the influence of drugs or alcohol?
Negative.
Is this plea freely and voluntarily given?
Yes, sir.
Are you the same person named in indictment number 23 CR 0062?
I am.
Is your judgment impaired today in any way?
No, sir.
Have you discussed this matter with your attorney? Are you satisfied with his advice?
I am
Have
indeed.
you reviewed the evidence the Commonwealth has against you? You believe you're fully informed about your case?
I believe so.
You do not have to enter a guilty plea today. You have certain rights under the Kentucky and United States Constitution. Before I can accept a plea, I need to know that you understand those rights. I'm going to go down through the rights and I'm going to ask at the end of it that you confirm, okay? You have a right not to testify against yourself. No one can make the same thing, right to speed trial, but jury right to confront and cross-examine all witnesses called against you. Right to produce evidence, the right to call witnesses in your favor, have process issues, compel attendance, you have right to appeal this matter, higher court if you lose. And right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty of charges. Don't you understand that by entering a guilty plea today, you give up all those rights? You understand that?
I understand that.
I may consider the Commonwealth's recommendation by may applying range of sentence by the law. If I don't accept the recommendation and decide to impose a harsher sentence, you have a right to withdraw your plea. I have a couple of qualifying questions I need to ask you. Number one, have you been previously diverted in the last 5 years?
No, sir.
Have you had any felonies in the past 10 years?
No, sir.
Are you currently on probation?
I am not.
You understand if you successfully complete the diversion agreement, the charges will be dismissed.
Yes.
You understand if you not successfully complete the diversion agreement, you'll be brought back before the court, and the court finds that you are not substantial compliance with the diversion agreement. We will schedule a sentencing hearing. You'll be convicted felon. You understand that?
Yes, sir.
Listen very carefully. What is the Commonwealth's recommendation in this court?
Yes, Your Honor. Upon a plea of guilty to burglary third degree, the defendant shall receive a sentence of 5 years, pretrial diverted for 5 years. Diversion is to be supervised until restitution is paid in full. The defendant agrees to pay restitution jointly and severally with co-defendant Timothy Hinchin, 23 CR 61, in the amount of $12,000 at a rate of $125 per month to Anthony G. Willis, payable through the Cumberland Circuit Court Clerk's Office. First payment being due within 30 days from the entry of this plea and due on the first day of each month thereafter until paid in full. The defendant shall obtain gainful employment or do 30 hours per week of community service until gainful employment is obtained. The defendant agrees to have any and all drug paraphernalia and contraband disposed of in accordance with the laws of the Commonwealth of Kentucky.
So what you agree to, sir?
Yes, sir.
Are you pleading guilty because you did commit the acts as charged in the indictment as amended?
Yes, sir.
Did you so of your own free will?
Yes, sir.
Knowing your constitutional rights, is it still your desire to proceed and allow the court to fix your punishment? Is
Yes,
that
sir.
your signature on the document?
It is indeed.
Okay, I'll accept the agreement and sign the diversion order and the restitution order. We'll hand it to the clerk over there. You meet with the probation parole officer right there, give him
Yes, sir.
information.
Thank you,
Thank you very much. Michael Graves. Commonwealth versus Michael Graves, 23 CR 0060. We're here for a pretrial conference. Are you Michael Graves?
Yes, sir.
You born in 1972.
Yes, sir.
Last four digits, social security number 9793.
Yes.
You're here today on a pretrial conference. What's the Commonwealth have to say?
We've made it out.
They have, Your Honor. Michael's got a matter in district court, which may potentially end up here. I think we've got that one settled. So I believe if we pass this to the fourth and be in person to the negotiation session, hopefully we can get it resolved.
Well, if we can either get it resolved then or we can set a trial date.
Right. Understand.
Is he ready to enter a plea today?
What's the delay here?
Your Honor, Mr. Graves, this all.
You need to stand over behind the
Sorry,
microphone.
this all stemmed from a search of his premises on a theft or receiving charge, and some drugs were found in his home. The original charges in district court, and Mr. Hurt and I have about got that one worked out, which means he won't have that problem here. So if he was going to get indicted on that, we want to bundle it all up. But I think we can avoid that. I think we're going to have a problem if we get this resolved. Plate's pretty full.
Well, one more pretrial since Mr. Cross is gonna be there. We can.
September the 29th,
Yes. Thank
the next court appearance, October 5th, both of them conditions of your bond. Timothy Henson. How do you pronounce your last name, sir?
Hinchin.
Hinchin, okay. 23 CR 0061. Mr. Hinchin, were you born in 1971? Last four digits, social security number 8709.
Yes.
You here today for pre-trial conference. What does the Commonwealth have to say?
We have a diversion plea, Your Honor.
The motion has been tendered that says you wish to enter a plea today. Is that correct?
Yes.
Are you currently under the influence of drugs or alcohol?
No.
Is this plea freely and voluntarily given?
What?
Is the plea freely and voluntarily given?
Yes.
Yeah. Are you the same person named in indictment number 23 CR 0061?
Yes.
Discuss this matter with your attorney, and are you satisfied with his advice?
Yes.
Have you reviewed the evidence the Commonwealth has against you?
Yes.
Do you believe that you are fully informed about the case?
Yes.
You understand that you do not have to enter a guilty plea today. You have certain rights under Kentucky and the United States Constitution. Before I can accept the plea, I need to know that you understand those rights.
Yes.
I'm gonna go down through the rights and then ask you at the end if you understand them, okay?
Okay.
You have a right not to testify against yourself. No one can make you say anything. Your right to speak trial by jury, your right to be represented by counsel at your jury trial, the right to confront and cross-examine all witnesses called to testify against you, the right to produce evidence, the right to call witnesses in your favor, the right to fill this matter in higher court if you lose, right to part of the Commonwealth, prove beyond a reasonable doubt that you're guilty of charges against you. Do you understand those rights?
Yes.
You understand that by entering a guilty plea today, you give up those rights. Now, I may consider the Commonwealth's recommendation, but I may apply any range of sentence allowed by law. I don't have to accept the recommendation. In the event I not accept the recommendation, the Commonwealth decides to impose a harsher sentence. You have the right to withdraw your plea and proceed to trial. You understand that?
Yes.
Okay, you've previously been diverted in the last 5 years. You have a pretrial diversion in the last 5 years.
You haven't done a diversion because you don't have a criminal history. No. Okay.
You have any felonies in the last 10 years?
No.
You understand if you complete this diversion program, the charge will be dismissed, pretrial diverted, you can get your record expunged. Do you understand that?
Yes.
Okay. You understand that if you're not fully complete the diversion program, you will be brought back in court, and if the court finds you violate that diversion program, you'll be scheduled for a hearing, you'll be a convicted felon. Do you understand that?
Yes.
You have any felonies in the future that could be used against you? You understand that?
Yes.
Okay, what is the Commonwealth's recommendation?
Upon a plea of guilty to burglary third degree, the defendant shall receive a sentence of 5 years, pretrial diverted for 5 years. Diversion is to be supervised until restitution is paid in full. The defendant agrees to pay restitution jointly and severally with co-defendant Ernest Gates, 23 CR 62, in the amount of $12,000 at a rate of $125 per month to Anthony G. Willis, payable through the Cumberland Circuit Court Clerk's Office. First payment being due within 30 days from the entry of this plea and due on the first day of each month thereafter until paid in full. The defendant agrees to forfeit a .22 LR revolver, Harrington Richardson Arms number 5N, to the Cumberland County Sheriff's Department to be disposed of in accordance with the laws of the Commonwealth of Kentucky, and to have all drug paraphernalia and contraband disposed of in accordance with the laws of the Commonwealth of Kentucky.
Tell me about the gun.
I don't think I'm convicted felon, Your Honor, so no charges in there.
Where was the gun?
It was on his person, on Mr. Hinkinson's person.
And what were the circumstances of this arrest?
Now, they were scavenging the abandoned home that burned partially. They were scavenging wire and things of that nature from that home.
It's a scrap.
But it was scrap after they took it from the home.
Yeah, that's what I meant, was they were gonna take it to scrap it.
Something just bothers me about someone out thieving, going and taking somebody's property from the house and being armed while they're doing it.
So, for driving.
If it helps any, Your Honor, I believe this firearm was like from the 1800s. Like it was
You
not.
want to bring it up here and let me see if it fire? You want to stand in front of it, we'll check it out. I don't really care when it was created, you know, I mean,
Right.
I just, you know, it bothers me that you got people going around thieving and armed and somebody comes up on them. What are they gonna do with the gun? Why do they have the gun? Are they gonna use the gun to take somebody out that comes on their own property?
They committed one prisoner restitution.
You understand what the offer is here? At $125 a month for $12,000, is that 10 years? How long is that?
There's two.
There's two people making it.
Going in several. First off, 25, 250, and one of them's on SSI, and I don't remember the situation on the other.
Did you understand this plea agreement that you have to make restitution as part of it? You understand that, sir?
Yes, I do.
You understand that you're not to have any firearms on you? You understand that, or
Yes,
in
I
your
do.
house or anything? You understand that?
Yes,
Are you pleading guilty because you did commit the acts in the indictment?
yes,
Knowing your constitutional rights, is it still your desire to give up those rights, enter a guilty plea and allow the court to fix your punishment when the arraignment permitted by law? Yes. Is that your signature on there?
Yes.
Okay, I'll accept the agreement, sign the diversion order. And also the restitution order. You need to meet with the probation and parole officer there. And if you get revoked on this thing, you'll be a convicted felon. And if you have another felony after that, it'll be enhanced under the persistent felony offender law. You understand that?
Yes, I do.
Meet with the probation and parole officer.
Thank you.
Thank you.
Johnny Key. Commonwealth versus Johnny Key, 23 CR 0056. Are you Johnny Key?
Yes, sir.
Born in 1957. Last four digits, social security number 0532. We're here for a pretrial conference. You understand that?
Yes, sir.
What's the Commonwealth have to say?
Diversion plea, Your Honor.
Motion has been tendered, sir, that says you wish to enter a plea of guilty today. Is that correct?
Yes, sir.
Are you currently under the influence of drugs or alcohol?
No.
Is this plea freely and voluntarily given?
Yes.
Are you the same person named in indictment number 23 CR 0056?
Yes.
Is your judgment impaired today in any way?
No.
Have you discussed this matter with your attorney and are you satisfied with his advice?
Yes.
Have you viewed the evidence the Commonwealth has against you? Feel like you're fully informed about your case?
Yes.
You understand that you do not have to enter a guilty plea today.
Yes.
You have certain rights under the Kentucky and United States Constitution. Before I can accept a plea, I need to know that you understand those rights. I'm going to go over those rights, sir, now. At the end, I'm going to ask you if you understand them. You have the right not to testify against yourself. No one can make you say anything. Right to speak, trial by jury, right to be represented by counsel at your jury trial, the right to confront and cross-examine all witnesses called to testify against you, right to produce evidence, right to call witnesses in your favor, right to appeal this matter to higher court if you lose, right to cry the Commonwealth, prove beyond a reasonable doubt that you're guilty charged against you. Understand that by entering a guilty plea today, you give up those rights. Understand that?
Yes, sir.
I may consider the Commonwealth's recommendation that I may apply any range of sentence allowed by law. I don't have to accept it. In the event that I do not accept the Commonwealth's recommendation, I'll give you and decide to impose a harsher sentence. I'll give you an opportunity to withdraw your plea and proceed to trial. I'm going to have some qualifying questions here. Have you previously been diverted in the last 5 years? No. Do you have any felony convictions in the last 10 years? No. Are you on probation now? No. You understand that if you fully complete the diversion program, the case will be dismissed, pretrial diverted. You understand that?
Yes.
You understand that if you do not complete the diversion program successfully, you'll be brought back before the court. And the court will schedule a sentencing hearing. You'll be a convicted felon, and any future felony convictions could be enhanced because of this. You understand that? Counselor, would you say what the Commonwealth's recommendation is?
Yes, Your Honor. Upon a plea of guilty to possession of a controlled substance, first degree methamphetamine, the defendant shall receive a sentence of 3 years, pretrial diverted for 5 years. Diversion is to be supervised. The defendant agrees to be assessed by the social services clinician and will follow any recommendations. Defendant shall obtain gainful employment or do 30 hours per week of community service until gainful employment is obtained. The defendant agrees to have any and all drug paraphernalia and contraband disposed of in accordance with the law of the Commonwealth of Kentucky.
Is that what you agreed to, sir?
Yes, sir.
Are you pleading guilty because you are guilty of doing the charges that are set out in the indictment?
Yes, sir.
Okay. Knowing your constitutional rights, I've explained to you, is it still your desire to give up those rights, enter a plea of guilty charges, not a court to fix your punishment, and range sentence permitted by law? Is that your signature on the document and offer?
Yes.
I'll accept the agreement, enter the orders. You'll need to meet with the probation and parole officer there. What costs, sir? The court costs of $185. You need some time to pay that?
Yes, sir.
You pay it $30 a month, starting 30 days from today. Okay.
And Your Honor, point of order, I've reviewed the PSI with Mr. Curtis. He wanted to recall his case.
You have it with you.
I do, Judge.
Better when you retrieve that for me. Thank you very much. Returning to the case of Commonwealth Kentucky versus Jeremy Curtis, which is 23 CR 0047, previously addressed the sentencing of Mr. Curtis at that time. He had not had the opportunity to review his pre-sentence investigation report under probation. Since then, sir, you had time to review that.
Yes, sir.
Is it substantially correct?
Yes, sir.
Counselor, is there any reason this gentleman should not be sentenced?
No, Your Honor.
Plea, on plea of guilty possession of controlled substance, first degree meth, the defendant shall receive a sentence of 3 years probated, 5 years probation. Is to be supervised and degrees to pay a fine of $200 plus court costs of what?
It's $265 plus.
$465. And the other conditions include go to the specialty court. And you need some time on the $465.
Yes, sir.
Okay, you'll pay $40 in 30 days from today. $40 a month till it's finished, okay? And you are enrolled in the specialty court.
Yes, sir.
Okay, you need to meet with probation and parole officer for them to give you some information, okay?
Sir.
Thank you very much.
Thank you, sir.
Yeah. Scotty Lay. Scotty Lay.
Your Honor, he is a co-defendant with Sarah Page. They are
Let
entering.
him get it. I'll give him front of me here. I'm over Scotty Lay, UCR 0018. You are Scotty Lay.
Yes, sir.
Born in 1967. That's the 4 digits social security number 2701. I'm sorry, Counselor. What did you have to say?
Your Honor, I was just gonna let the court know that he's a co-defendant with Sarah Page. We also have an agreement in her case. His is for probation, hers is diversion. I just didn't know if the court wanted to take them up at a similar time or not.
Separately, but are you represent both of them?
Yes, Your Honor.
They signed a waiver of dual representation.
Yes, Your Honor. And I would like to state it on the record that they were okay with me representing both of them in this matter.
Is that correct, sir?
Yes, sir.
Okay. So you're going to enter a regular, is it felony plea?
This is a felony plea on Mr. Lay, Your Honor, and there's also a DUI.
Okay, motion's been tendered, says you wish to enter a plea today, is that correct?
Yes.
Are you currently influenced with drugs or alcohol?
No.
Is this plea freely and voluntarily given? Are you the same man that was identified in 22 CR 0018?
Yes.
Okay. Discuss this matter with your attorney.
Yes.
Is your judgment impaired today?
Yeah.
Are you satisfied with your attorney's advice?
Yes.
Do you view the evidence the Commonwealth has against you?
Yes.
Believe that you're fully informed about your case. You don't have to enter a guilty plea today. You have certain rights under the Kentucky United States Constitution. Before I accept the plea, I need to know that you understand those rights.
I understand.
I'm going to go down through the rights, and at the end, I'm going to ask you if you understand them. If you don't, you step away and ask your attorney. You have a right not to testify against yourself. No one can make you say anything. Right to speed trial, the jury, right to be represented by the counsel at the jury trial, the right to confront and cross-examine all witnesses called testify against you, right to produce evidence, the right to call witnesses in favor, the right to appeal this matter to higher court. If you lose, the right to require the Commonwealth prove on reasonable doubt that you're guilty charged against you. Understand that?
Yes.
By entering a guilty plea today, you give up those rights. You understand that?
Yes.
I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided by law prior to accepting your recommendation. I'll wait pre-sentence investigation report from probation and parole as to the felony. In the event that I do not accept the Commonwealth's recommendation, decide to impose a harsher sentence, you have the right to withdraw your plea and proceed to trial. Mr. Stockton, what is the Commonwealth's recommendation?
Your Honor, Mr. Lay will enter a plea of guilty possession of controlled substance, first degree, a sentence of 3 years, be probated for 5 years supervised. He'll plead guilty to DUI, first offense. He'll receive a fine of $300, 7 days in jail. He'll get credit for time served. You'll also pay a fine of $500 on the no insurance. Pay court costs at discretion of the court.
Is that what you agreed to, sir? Are you entering this plea because you are guilty of the acts charged in the indictment?
Yes.
You serve your own free will?
Yes.
Okay. And you understand that by entering this plea of guilty, any future convictions of felonies could be enhanced in the persistent felony offender law?
Yes.
You also understand that under our DUI laws in Kentucky, if you get another DUI, that it can be enhanced. You understand that?
Yes.
Knowing this explanation of the constitutional rights and what the statute requires, so your desire to proceed your guilty plea and allow the court to fix your punishment. Is that your signature?
Yes.
On that? I'll accept the agreement. What are the costs of all this? And you owe $1,375. Okay, can you pay $60 a month?
No, as of right now, I'm not trying to get SSI and it's on the field. I can't work right now.
You could do 30 a month, Your Honor, if that's okay for right now.
I'll split the difference. Put $40 a month first payment, 30 days from today. That was your signature on the document. I accept the agreement. You need to be the probation parole officer. Okay? Okay, thank you.
Your Honor, did you want to set him for a separate sentencing or was he being sentenced today? We are okay if he's sentenced today. We just, I wanted to.
No, you'll have to come back to be sentenced. He had a felony conviction. We could do the DUI today, but we'll do them both the same day.
That October 5th?
October 5th, wasn't it?
Yes.
5th. Mark Martin. Mark Martin. He's active warrant out for Mr. Mark Martin. John Metz, active warrant out for John Metz. Did you get that, Mr. Shaw? Stanley Michael. Stanley Michael. Active warrant out. Sarah Page. Commonwealth of Kentucky versus Sarah Page, 22 CR 0019. Are you Sarah Page?
Yes, sir.
You're born in 1969.
Yes.
Last four digits, social security number 36. 10.
Yes.
You're here to enter a plea today, is that correct?
Yes.
What kind of plea is this? Is it a felony plea?
No, it's diversion, yeah.
Motion's been tendered that says you wish to enter a guilty plea. They say, is that correct, ma'am? Are you currently under the influence of drugs or alcohol? Is this plea freely and voluntarily given?
Yes.
Are you the same person named in indictment number 22 CR 0019?
Yes.
Is your judgment impaired today in any way? Is your judgment impaired? Do you know what's going on here?
Yeah, I think so, yeah.
Do what?
I guess they're right. I do have some problems. I have seizures.
She's in a lot of pain right now, Your Honor, so it does hurt. That's why it just takes her.
Have you had plenty of time to discuss this matter with your attorney?
Yes,
Are you satisfied with her advice?
yes,
Have you reviewed the evidence which the Commonwealth has against you?
yes,
Do you believe that you've been fully? You believe you've been fully informed about your case?
yes,
You understand that you do not have to enter a guilty plea.
yes,
You have certain rights under the Kentucky and the United States Constitution. Before I can accept a plea, I need to know that you fully understand those rights. I'm going to go down through them, and at the end, I'll ask you to acknowledge you understand them, okay? You got right not to testify against yourself. No one can make you say anything. You have a right to speed trial by jury, your right to be represented by counsel at your jury trial. Right to confront and cross-examine all witnesses called to testify against you, right to produce evidence, right to call witnesses in your favor, right to appeal this matter to higher court if you lose, and right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty charged against you. Understand it, but entering guilty plea today, you give up all those rights. You understand that?
yes,
I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided by law. If I do not accept the recommendation and decide to impose a harsher sentence, you can withdraw your plea and proceed to trial. You understand that? Yeah, I'm gonna ask you some qualifying questions. Have you had a pretrial diversion in the last 5 years? Have you had any felonies in the past 10 years? You have to say something.
No,
Okay. Are you
Never.
currently on probation?
no,
Okay, you understand if you fully complete the diversion program, the charge could be dismissed, pretrial diverted. Do you understand that?
yes,
You understand that you not fully complete the diversion program, you'll be brought back before the court will schedule a hearing.
yes,
And if you're revoked, then you'll be a convicted felon and that can be used against you in the future. You understand that?
yes.
Listen very carefully. What's the Commonwealth's recommendation?
Your Honor, Ms. Page plead guilty to possession of controlled substance first degree, receive a sentence of 3 years. Tampering with physical evidence, a sentence of 5. They will run concurrently for a total of 5 years. She'll receive credit for time served. And all these will balance be pretrial diverted for 5 years.
Is that what you agreed to? Is that what you agreed to?
Yes,
Okay, are you pleading guilty because you did commit the acts in the indictment as amended? Knowing your constitutional rights have explained to you, it's still your desire to go forward, enter a plea, and allow the court to fix your punishment.
yes,
Is that your signature on the document?
yes,
I accept the agreement, sign the pretrial diversion. You'll need to meet with probation pro office for the court costs. The court costs are $265. You need some time to pay that.
Yes, Your Honor.
Okay, I'll let you pay the first payment 30 days from today, which is $30 and $30 every 30 days until it's paid in full, okay?
yes. I think I,
I'm gonna switch over to Barron County just for a second. Barron County, are you on there? Running just a little bit late, I apologize. Could you see if we have Johnny Gold there? Johnny Gold. Are you Johnny Gold? Are you Johnny Gold? This is 21 CR 0023, Mr. Gold. We're on a pretrial diversion revocation. What's the Commonwealth have to say?
Your Honor, this is a case where
Speak up a little bit.
Mr. Goat has a new felony charge of possession of firearms by a convicted felon. Evidently, 2 officers were chasing a fugitive and they ended up in the truck at Mr. Goat's property. The probation pro officer went in and they searched his residence. They found guns locked up in a safe that he claimed was his girlfriend's and also found marijuana paraphernalia.
Mr. Gold is innocent, proven guilty, and again, he made the claim that these were his girlfriend's firearms and drugs, so
Was it his home?
it was, Your Honor.
No, the guns are there. It doesn't matter who they are. Not supposed to be anywhere with guns, so you just say he claimed that they were girlfriends, so you acknowledge they were his.
I've got Ms. Baker prepared to testify.
You raise your right hand, man. Swear the testimony you're about to give is the truth, the whole truth, nothing but the truth.
I do, sir.
Proceed.
Ms. Baker, have you been supervising Mr. Gold?
Yes, sir, I have.
And during that time of supervision, has he had any violations?
Prior to the current violations that we're talking about, he had none that I can see of it as recently. It looks like he had a use of marijuana, or I'm sorry, use of methamphetamines in January of 22 and another use of marijuana in December of 22. But for the year of 2023, he didn't have any until this incident.
Well, let's talk about these current violations. What are those violations?
It's going to be for possession of a firearm, possession of drug paraphernalia, possession of ammunition, and use of controlled substance marijuana.
Okay, has Mr. Gold been indicted in Barron? Not indicted, has he been charged in Barron District Court with a felony as regards to firearms?
Yes, sir, he has.
Okay. Now, do you know about the facts of the case as regards to firearms?
I was there, sir.
You were there?
Yes, sir. I'm one of the probation officers that went to the residence.
Did you tell the court what happened?
Yes, sir. So initially it started out as a complaint that we received of a subject who's also on probation that had an active warrant, and received a complaint that he was there with Mr. Goad actively using drugs. So we responded to the residents, me, Officer Bragg, and Barron County Sheriff's Office. Upon arrival at the residence, Mr. Goad greeted us at the residence, invited us in. We asked for permission to search the residence with the intention of trying to find the fugitive. And upon searching the residence, we located several firearms within the residence. And then once
Okay, what were the firearms and what kind were they?
Well, the ones in the safe, I believe there was over 20 different ones. Those consisted of long rifles, shotguns, etc. Those were locked in a safe that was hidden behind the entertainment center. The ones that he was charged with for the possession of the handguns, reference to the sheriff's deputy charging him, were ones that were handguns that were located next to him where he was sitting in the chair. So upon entry into the residence, he sat down in a recliner located in the living room. After we began our search, I had him detained, and then we moved a t-shirt that was next to his chair where he had been sitting, and there was a firearm located there. That was a handgun. I asked him if there was any more firearms in the residence. He said that there was 2 more handguns located at the coffee table, also located next to his recliner where he had been sitting. And then that's when he told us about the gun safe located behind the entertainment center. And throughout the house, there was ammunition all over, freely just sitting everywhere, which is what gave us the inclination that there was firearms in the home.
So just to clarify, there was 3 handguns in his immediate vicinity?
Yes,
Yeah,
sir, within
recliner.
arm reach. Yes,
Okay.
sir.
And I guess the fugitive that you was looking for was found at that residence?
That is correct, sir. It was a truck that he had been working on that it didn't run, that the fugitive was found inside the truck hiding.
Yeah. I don't have any others. One other question, and was there marijuana located at the residence?
Yes, sir. The marijuana was located, and the pipe paraphernalia was located right next to his chair on like a little like TV dinner table that you keep next to the chair, next to his cell phone, next to his cigarettes.
I have no other questions.
You like to inquire, Counselor?
Briefly, Your Honor. So besides Mr. Gold and this fugitive, was anyone else at the residence?
Yes, sir. His girlfriend.
Just her?
Yes. Now, we had later asked the neighbor, she had asked the neighbor later on to come and remove the firearms that were not confiscated by Barron County Sheriff's Office. So we had a third person show up at the residence and remove the firearms that were in the safe. But other than that, it was just the fugitive, Mr. Goad, and his girlfriend.
This third person, they were able to access the safe?
I'm sorry?
They were able to access the safe?
We had already accessed the safe. They opened it for Mr. Goad, and his girlfriend opened the safe for us so that we could see what was inside the safe, and we pulled out the firearms. After Mr. Goad was taken into custody and the fugitive was taken into custody is when the neighbor came over, and in the presence of me and another officer, we had the firearms removed by him.
Thank you. Those are all the questions I have.
No other witnesses.
You want to call any witnesses? No, it's an obvious violation of firearms.
No, Your Honor.
Would you like to say something?
No, Your
Or
Honor.
you just disagree about a
I
rule
was saying-
before you appeal it?
No. I was saying I don't want to call any witnesses, Your Honor.
I'm going to find Mr. Gold violated the terms of this pretrial diversion and ordering a pre-sentence investigation for him by probation and parole. We'll have him back here on October the 5th for sentencing. Dallas Hayes. Carroll County and Bourbon County, we got 3 cases down. In Marion County detention, we got 3 cases before y'all. Dallas Hayes, are you Dallas Hayes?
Sir.
We're here today on 23 CR 0006 for a pretrial conference. What does the Commonwealth have to say in 23 CR 006?
Your Honor, Mr. Hayes was in rehab pending this case and he left there. And then I think he's recently been picked up. I don't know if Mr. Pennington's spoken with him or not.
No, this.
Okay, we'll have him for a negotiation day on September 29th. The next court date is October the 5th. Both of them are conditions.
Yes, Your Honor.
Jimmy Smith. What's Mr. Hayes' bond? Okay, we'll keep that. Jimmy Smith. Commonwealth versus Jimmy Smith. 22 CR 0098. Are you Jimmy Smith? Born in 1987. Last four digits of social security number 2981. You're here today on a probation revocation. What does the Commonwealth have to say?
It appears Mr. Smith has a 3-year sentence on possession of a controlled substance, and he's been charged with absconding. He didn't report in June. It looks like they had trouble getting his probation transferred in April, and he hadn't been contacted since he was picked up.
We'll stipulate.
Yes, Your Honor.
Okay, stipulate and we revoke his probation. I hope you get things turned around, Mr. Smith. Robert Stevenson. Commonwealth versus Robert Stevenson, 21 CR 00113 and 21 CR 00126. Are you Robert Stevenson?
Yes, Your Honor.
Born in 1986. Last four digits of your social security number 0778. Is that correct?
Yes, Your Honor.
We're here on probation revocation. What does the Commonwealth have to say?
Your Honor, this is our second motion to revoke. This was before the court previously. Mr. Stevenson has a 7.5-year sentence. Previously, he tested positive for fentanyl, marijuana, and meth. He went to Recovery Works, a 6-month program, and completed that. After he completed that program, then he tested positive for meth May the 23rd. Mr. Collins, I believe, is on if we need testimony. But at that point in time, we were going to put him in drug court in lieu of revocation because this Cumberland County case occurred after the Monroe County case. I didn't realize he was in drug court in 2014. He was in drug court in 2021. He was terminated in 21 because he had an assault case in Monroe County. So he's not eligible for drug court. So I'm just going to ask for revocation at this point in time because he's already been to rehab. He's completed that. He's been to drug court twice and he's still testing positive for drugs.
His plea agreement say he would be probated and sent to drug court. Is that what it said?
No, when we were, this is actually a motion to revoke his probation. This came up after he was released.
Need to wait till you get back in front of the microphone. Get back in front of the microphone.
Oh, this is not part of the plea agreement.
So it was in lieu of revocation.
That's correct.
He did not comply.
He didn't comply.
You want to stipulate?
Judge, with this one, I mean, at the crux, this is substance abuse. Him staying incarcerated is not going to help him get his problem treated. I know he can't go to drug court, but we would ask for some long-term rehabilitation at this point. I know he tried Recovery Works, but 6 months is sometimes not enough time.
Yeah, that's what y'all had offered last month, but I never heard anything from the public defender's office. Your Honor, you told me I could go to a treatment center, and I never heard anything from the public defender's office to verify my bed date.
Well, the problem was he went to the treatment center. He completed that. We were going to put him in drug court. It wasn't anything to do with treatment. It was going to go into drug court. He didn't qualify.
And now you found out he wasn't eligible.
He wasn't eligible because he'd been there twice already and completed. I mean, I don't know. Do we still have the SAP program at the penitentiaries? I mean, everybody wants rehab, but they don't want to do that. But that looks like the only kind of treatment it's going to take.
Well, since he's not eligible for drug court, since he's previously completed the 6-month situation, I'm going to have to revoke Mr. Stevenson. Put strong recommendation that he receive SAP program while he's incarcerated.
Yes, Your Honor.
Is there anyone else in Barron County?
Yes, Your Honor, we have Edward Whitledge and Marlon Stout.
You have them on your docket, Mr. Stockton?
Yes, Stout is co-defendant with Dustin Jesse, has to be an alternate trial date because all the officers in training, so we can schedule. He's on the transportation vehicle.
He's actually, it's just an ex parte motion, so we would waive his in-person hearing if the jail.
Which one of them you talking about?
Mr. Whitledge.
Okay. We'll have to go back to Mr. Whitledge then. And Marlon Stout. Marlon Stout.
Yes, sir.
Commonwealth versus Marlon Stout. 3CR 007. We're here on a motion for an alternate trial date. What do you have, Mr. Stockton?
Your Honor, this case is set for trial in
Monroe County on September the 14th, when we issued, when we issued subpoenas, September the 11th, I'm sorry, is when it's set for trial. When we issued subpoenas, we didn't realize there's officers in Barron County that's involved in this. This is where the stolen property was found. And they've all have their annual training. They're gone that week. So we're asking for an alternate trial date.
Do you have a co-defendant?
I do.
Who's your co-defendant?
Dustin Jesse.
Let's pull Dustin Jesse, come up there too. Your attorney's here, Mr. Jesse, also.
Judge, he's out of custody.
Is he here?
I told him to come to work school, but I guess the automated system gave him a text and told him to show up in conference room, so he's been there and now he's on his way here.
Megan, will you bring the briefcase out with the calendar in it? I thought it was already out here.
Yeah.
Excuse me. When was this previously scheduled for?
It was the 11th, Your Honor.
What?
It was the 11th.
September.
Get the dates those officers will be available.
They're just not available that week, Your Honor, of the 11th.
What about October the 2nd? How about the 10th, October the 10th?
That's fine. Maybe.
That's fine with me, Your Honor.
Stout and Jesse. Okay.
Thank you.
Then we'll have to come back to Barron County a little later for Mr. Whitledge, but we're gonna have to get him in the side room or something there to have an ex parte motion. So if y'all just, we're finished with everyone else but him, and we'll come back to you in a few minutes because we'll have to take him to downstairs. We'll have to go to the downstairs courtroom to recontact you. We'll do that in a few minutes. Bourbon County Detention Center. Bourbon County Detention Center. We'll be in contact with them. Carroll County Detention Center. Marion County, I see you patiently waiting. Marion County. Okay. Marion County, Commonwealth versus Barney Sheverson, 20 CR 0030. Are you Barney Sheverson?
Yes, sir.
Okay, we're here on a motion for shock probation. Counselor, you can proceed.
Yes, Your Honor. I filed this motion on behalf of Mr. Shepperson. He was revoked by this court on June 29th of 2023. He served 63 days since then. Your Honor, this was a case that sort of took a while to come back to court on a motion to revoke because Mr. Shepperson had probation in other counties. He had actually served part of his sentence that on parole out of Adair County that was done originally at the same time as his Cumberland County case. So he has served, while it's not reflected in this motion, he has served quite a bit of time since this case originally came to before the court.
How much is quite a bit?
Well, he's on his Adair County case several months before being paroled back
That's
out.
not on this case, though, is it?
No, Your Honor, but they arose at the same time and they were concurrent, but he was never revoked on his Cumberland County case, even though he was revoked on his Adair County case, because this motion.
You want to get involved in this, Mr. Stockton?
And it wasn't a fault of Mr. Stockton. The Commonwealth was not
I'm fixing to
informed.
blame it on this.
No, the Commonwealth here was not informed.
Mr. Stockton. Yeah.
Well, he was revoked. My understanding was on the 7-year sentence, he was revoked in June 29th of 2023 in this case, but he absconded in October of 2022. That was the problem we had located. I think he was gone about 9 months, 10 months before he was located to be revoked.
On his parole,
You
Your Honor.
left that portion out.
I was getting there, Your Honor. So he has served, Mr. Shepperson had several cases at the same time that he was probated on, was revoked on some of them and then
Mr.
paroled out.
Stockton, what do you want to do on this?
Well, the problem was he absconded. He stayed gone for 9 months. Then he had a bail jumping conviction out of Adair County to go along with his flagrant non-support. And my understanding from talking to Mr. Garner is he's currently a state inmate. Even if he got shot, he'd still be a state prison. So I'm opposed to shock probation because of those facts.
I think on his parole, Your Honor, he would be a state inmate, but the reason we still filed the motion is because there is confusion about what his ultimate credit would be as far as the state sentence. So if he was shock probated on this case, there's potential that they could parole him out on his other cases. And I say potential because I honestly don't know what DOC will do.
I don't think so with the absconding and the other violations. I'm going to deny that motion for shock probation. And that way it would be easier to compile it if they keep it all together like that. I think you'll be better off, actually. So Marion County, thank y'all very much.
Thank you.
Yeah. Now, I guess somebody needs to contact Bourbon County and Carroll County, see when we can get them back on. I'm going to go. Bourbon County is on now. Bourbon County, are you on? Okay, well, I'm gonna go back to the live docket until we get Bourbon County on. Ricky Purdue. Commonwealth versus Ricky Purdue. 23 CR 0029. Are you Ricky Purdue?
Yes, sir.
You're born in 1981.
Yes, sir.
Last four digits of social security number 1284. You're here on 23 CR 0050. Is that correct? On a pretrial conference, what's the Commonwealth have to say?
Well, his co-defendant, Mr. Fields, was up here previously, so I guess he needs to be here on the 29th at 9 with counsel and on October the
Is
5th.
this the one where you didn't know whether you're gonna have conflict or not?
Right, Judge. It's,
Okay. Well,
it's not charged as
which one of
co-defendant.
these two gentlemen are you gonna take if you do have conflict? I know it's difficult for you to decide which one of them.
Judge, it'll probably be Mr. Purdue.
Well, Mr. Purdue, you be here on the 29th of September for negotiations, and then you'll be here on October 5th, and you have reached agreement, we'll set your trial date, okay?
Thank you, Judge.
Charles Perkins. Commonwealth versus Charles Perkins. 23 CR 0029. Are you Charles Perkins?
Yes, sir.
Born in 1981.
Yes, sir.
Last four digits of social security number 9080.
Yes,
Here for a pretrial conference. What does the Commonwealth have to say?
We've made an offer in this case.
And Judge, this was one that was not on for negotiation, so it was not one that I had prior received. If we could just get another pretrial conference with the negotiation.
September the 29th for negotiations, October 5th, and reach an agreement, then we'll set your trial date. Okay?
Yes, Your Honor.
Darian Riddle. How you say, I've always wondered, hey,
That's Darren.
Darren?
Yeah.
Darren Riddle, 23 CR 0057. Are you Darren Riddle?
Yes, sir.
You were born in 1972.
Yes.
Last four digits, social security number 4086. Is that
Yes.
correct? Your day for pretrial conference. What's Commonwealth?
We've made an offer. I don't know what their position is.
And Judge, much like Mr. Perkins' case, I think this is one with one more pretrial. We'll be ready to set it for trial. Come back in October.
September the 29th for negotiation here, and October the 5th.
Yes, Your Honor.
Okay. Have a settlement or a trial date on that?
Yes, Your Honor.
Janisa Smith, arraignment. Commonwealth versus Janisa Smith, 23 CR 0068. Are you Janisa Smith? Are you born in 1989? Last four digits of social security number 1768. You have her file here. Are you represented by an attorney? Can you afford an attorney?
Not at this time, no.
I can't hear you.
Not at this time, no.
You what? Public advocacy that represents you in district court. I'll continue that representation.
Judge, I will enter a plea of not guilty.
Wait just a second. Let me. You have a right to remain silent. The grand jury of Cumberland County has returned an indictment charging you with theft, unlawful taking, or disposition. More than 1,000, but less than 10,000. Disorderly conduct. Giving a police officer a false name. Operating while you are revoked. Operating all-terrain vehicle on a public road and failure to illumine your headlights. Mr. Bailiff, Counselor, you acknowledge the identity of your client, receive the indictment, wait formal reading, and enter plea of not guilty, reserving all pretrial motions.
Yes, Your Honor.
We'll set this lady for negotiations on September the 29th at 9 a.m. The next court date is October 5th. There any complaints about her bond?
No.
Okay, we'll see. Both of those are conditions of your bond. You understand? Okay. Thank
Thank you, Your Honor.
you. Keith Smith. Commonwealth versus Keith Smith. David Cross represents.
He informed me, Your Honor, he had to go step out some sale of real estate. Could he be back?
There he is.
Yeah.
Commonwealth versus Keith Smith, 23 CR 0024. Mr. Smith, you were born in 1963.
Yes,
Last four digits, social security number 8253.
yes, sir.
You're on 23 CR 0024. Pre-trial conference and a motion to suppress.
Yes, Your Honor, the Commonwealth and I have had, I think we're on the verge of resolving it subject to the court's approval. But I don't know,
Nothing's ever that easy with Mr. Krause, so I don't think we're on the verge. We're close.
well,
That's a start.
Yeah.
that's correct. It is and Your Honor, to explain, Mr. Smith has a 35-year-old felony conviction. He's charged with possession of a firearm. His position is he had no idea he wasn't allowed to have one. I've requested that pursuant to plea and withdraw the motion, that charge be dismissed. And I believe the court's had some reluctance to do that in most cases, understandably. But this is kind of a different animal, I believe, under the set of
That's not
circumstances.
a proposal that I have.
Yeah.
What was that, man?
Must have been at a different meeting, Mr. Cross.
So I know Miss Anne Marie was talking to you, and we may have miscommunicated a little bit.
Perhaps.
Yeah.
Yeah, that was my discussion with her. I'm sorry.
Pre-trial conference. What kind of motion to suppress here?
It's regarding the stop and the extension of the stop.
This is the one where they looked at the license plate to see whether there's any insurance, or is
Yes.
that another motion? Yeah, okay.
If you want to pass it, and then we come back and have either a
Yeah, we'll
resolution or.
pass it to the end of the docket.
Okay. All right. That'll give us time. Just wait. Okay.
I've also got
Mary Beth Stalker, I got to run down through these.
I know,
here.
and I'm in the middle of an auction right now. I'm going to have to be tied up in it for
Okay,
a bit longer.
Mary Beth Stalker. Commonwealth versus Mary Beth Stalker, 23 CR 0038. You are Mary Beth Stalker, born in 1983, last four digits, social security number 2212. Is that correct?
Yes, sir.
Okay, this is a pre-trial conference.
We did, Your Honor, and we met, and Mr. Penny and I discussed this case last time, and I told him that there was some more investigation due, and that was my fault. I miscommunicated with the victim on that. So if we could have one more pretrial, if we can't settle it, then we'll.
Negotiation on September the 29th, and next court date is October the 5th, okay?
Okay.
Yes, Your Honor.
So you understand that, there's no more investigation.
Chandra Warren. Commonwealth versus Chandra Warren, 23 CR 0026. Are you Chandra Warren?
Yes, sir.
You born in 1980.
Yes, sir.
Last four digits, social security number 8790.
Yes, sir.
We're here today on a pre-trial conference. What does the Commonwealth have?
Your Honor, we're still trying to get the co-defendant in custody. So maybe if we would set
Who
this,
is the co-defendant?
David Hammer. You don't know where he is. He is. Oh, okay, well, good. Is he on today? Okay.
It's on the docket.
Now that he's in custody, I don't know if Mr. Pennington can represent both of them or not, so it'd probably be wise to set it for a pretrial and a negotiation date.
Well, Mr. Hammer is on the Adair County detention docket that we're running a little behind on. So we'll go ahead and set this on September 29th for negotiations and October 5th. And you all have to see if there's a conflict. If there is, you need to make sure the conflict council gets these dates and time.
Yes, Your Honor.
So the public defender's office may be in contact you as to whether they're going to represent you and Mr. Hammer, who your new attorney is, and attorney will be, okay? Thank you very much. Carol White.
I understand she's in custody in Tennessee.
Do what? There's a warrant from here.
She's in custody. We'll put a hold on her. We'll put her in CIC.
James Williams. James Williams.
Yes, sir.
This is 23 CR 0065. Mr. Williams, you born 1967.
Yes, sir.
Last four digits, social security number 1636.
Yes, sir.
Here today on a pretrial conference. What does the Commonwealth have to say?
We have the diversion plea, Your Honor. I'm sorry.
Yeah, we did not.
Okay.
Sorry, jumped the gun a little bit.
You don't have one?
Yeah, we do not, Judge.
Yes, we need travel.
What's this charge?
After marijuana, drug paraphernalia, DUI, maintain insurance, no registration.
And Judge,
What's the trial date? We have 12th, September 12th. Is that right, Mr. Stockton?
We do, and we also have the 19th and the 20th. If you, September 2 is cleared up.
With the Bricker case?
Yes. I know the 12th, our office may be shorthanded a little bit that week.
Okay, well, let's look at the 19th and 20th.
Judge, I will be out of state that week. Through the 26th of September.
What about the October?
And Judge, I was going to say, I know, diversion has been offered. I think we're close. I just need to check some disability eligibility problems because there was some time to serve mixed in with that diversion agreement on the DUI charge.
I don't understand what you're saying. What disability are we talking about?
To make sure serving the time would not hamper Mr. Williams' Social Security.
Because it's
disability.
check off.
Well, it's home incarceration.
It wouldn't be no disability. I'm on Social Security, like I said.
Well, I won't tell them if you want. So. Is it in home incarceration? The ankle bracelet.
Served 90 days home incarceration, balance deferred for 5 years. Upon a plea of guilty to operating a motor vehicle, defendant shall receive a sentence of 2 days and a fine of $200. So that was 2 days to serve, was my understanding.
That's correct. And I think it's 30
It's
days.
mandatory, isn't it?
Yeah, it is. 30 days is what it used to be before they would be anything with your SSI.
That's just what I've not checked the eligibility status. I don't know if it's Title 9, Title 16. That's just what I was informed. I hadn't had a chance to check for Mr. Williams on that. But that's the only snag.
I'm just gonna say the trial date.
We actually have an agreement. Mr. Williamson has executed the Commonwealth's offer on guilty plea.
Commonwealth versus James Williams, 23 CR 0065. Mr. Williams previously identified himself. Was this a diversion or probated sentence?
It's a diversion, Your Honor.
Diversion on that, and then there was a DUI also, was there?
Yes.
Okay. A motion's been tendered, says you wish to enter a guilty plea, Mr. Williams, is that correct?
Yes, sir.
Are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely and voluntarily given?
Yes, sir.
Are you the same man that is, same person that is named in 23 CR 0065?
Yes.
Is your judgment impaired today in any way?
No, sir.
Have you discussed these charges with your attorney? Are you satisfied with his advice?
Yes, sir.
Have you reviewed the evidence the Commonwealth has against you? Believe you're fully informed?
Yes.
You understand that you do not have to enter guilty plea today. You have certain rights under the Kentucky United States Constitution. Before I can accept the plea, I need to know that you understand those rights. I'll ask you at the end if you do. If you don't, you step away and talk to your attorney. Okay? You understand that you're not required to testify against yourself. No one can make you say anything. You're right. You're entitled to a speedy trial by jury. You're represented by counsel at your jury trial to confront and cross-examine all witnesses called to testify against you. Produce evidence. Call witnesses in your favor to appeal this matter to higher court if you lose and require the Commonwealth to prove beyond a reasonable doubt that you're guilty of charges against you. Understand that by entering your plea, they give up those rights. You understand that?
Yes.
I may consider Commonwealth's recommendation. I may apply any range of sentence provided by law. I do not have to accept the recommendation. In the event I do not accept the recommendation, decide to impose a harsher sentence, you have the right to withdraw your plea of guilty and proceed to trial. Have you previously been diverted in the last 5 years?
No.
And any felonies in the last 10 years?
No.
Are you on probation now?
No, sir.
You understand that if you successfully complete the diversion program, the felony charges will be dismissed in here.
Yes.
If you don't complete the successfully completed, you brought back in front of the court, the pretrial diversion is revoked. I order a pre-sentence investigation report, and then you will be sentenced, you'll be a convicted felon, that can be used against you in the future. You understand that?
Yes.
You understand if you have a guilty plea on a DUI, it can be enhanced in the future also if you have another DUI.
Yes.
Okay. What is the Commonwealth's recommendation?
Upon a plea of guilty to trafficking in marijuana more than 5 plants, the defendant shall receive a sentence of 5 years, serve 90 days home incarceration. Balance pretrial diverted for 5 years. Diversion is to be supervised. Upon a plea of guilty to operating a motor vehicle with alcohol concentration over above 0.08 or while under the influence of alcohol or other substances, first offense, then it shall receive a sentence of 2 days and a fine of $200. The defendant shall pay a fine at the discretion of the court, shall obtain gainful employment or do 30 hours per week of community service until gainful employment is obtained. Defendant agrees to have any and all drug paraphernalia and contraband disposed of in accordance with the laws of the Commonwealth of Kentucky.
Is that what you agreed to, sir?
Yes, sir.
Are you pleading guilty because you did commit the acts charged in the indictment as amended?
Yes, sir.
You understand? Are you doing so of your own free will for no other reason?
Yes.
Knowing your constitutional rights, still your desire to proceed with your plea, allow the court to fix your punishment within the range permitted by law. Is that your signature on the motion in order?
Yes, sir.
Okay, now, what is the total cost on this? Your total cost is $875. You need some time to pay that.
Yes, sir.
Yeah, let's pay it $40 a month. The first payment will be 30 days from today. Okay, $875. That's your signature on the motion offer. That's your signature there.
Yes, sir.
Sign it in open court. You meet with the probation pro officer there. You'll have to do the compliance with the DUI agreement there too. Okay? Thank you very much.
Thanks, Judge.
Cody Willis. Cody Willis. Albert Wilson, while we're waiting for Cody Willis, Albert Wilson. Let's go to Ethan Wilson, your attorney's back there and doing something. We'll call you right back there. Cody Willis, Commonwealth versus Cody Willis, 23 CR 0040, Cody Willis, born in 1989. Last 4 digits of Social Security number 2394. This motion revoke bond and a pretrial conference. What's the Commonwealth have to say?
Well, I didn't see Mr. Willis
You
here.
have, who represents you, Mr. DDA? He's going to represent himself. We did the hearing last week. So he didn't want a lawyer, is that right?
I just ain't been up before.
Well, that's not the issue. Last week you said you wanted to represent your case, and I went through the whole hearing and you want to represent your case. Now you say you can't afford one now. You don't want a public advocate to represent you.
Yes, sir.
That's a wise decision. But, so you got one now. Go ahead and proceed, Mr. Scott.
Your Honor, I was just notified by Mr. Smith that the last time we were in court, he was behind on his payments. He got that caught up, and then I received a letter from Mr. Smith that he hadn't been paid in the last 20 days. So I filed a motion to revoke his bond because he wasn't paying his home incarceration. He did have. But I don't know. I believe you. I just didn't know if he still had it on or not, but that was the complaint from Mr. Smith.
You got what?
Some messages I had printed off or whatever, right message, Junior, this monitor, like if you stay charged up or whatever, I asked you if you had another one that he could swap it out.
Well, you're not paying him. It's hard to provide another one if they don't get paid. So what's his bond besides the ankle bracelet?
He's in our property. Standard conditions.
Well, I'm caught in the middle of a dispute because he's not paying. If I was in a business, I wouldn't want to furnish a service.
Well, I'm
without
not
being paid.
saying he's not going to have to furnish it, but I'm wanting to look at why did we put an ankle bracelet on him instead of just a normal?
Well, I guess he's got a significant criminal history, multiple felons, and this is a theft case, the allegations in this. I'd say that's the reason you probably want to keep tabs on.
I'm willing to help him catch it up again today.
Well, help him catch it. And are you saying you're willing to pay it today?
I'm not sure exactly.
Well, they can get you back out when you pay it. I want you to pay it a week in advance. Pay it up and you pay a week in advance. No.
Well, I'd prefer, Your Honor, if I could interject, since this is an ongoing issue, I'd like to sit, and we're going to have a pretrial probably with Mr. Pennington. Maybe you could pay a month or two in advance. He's going to be on home incarceration. We won't have this issue till we can resolve the case or get a trial date.
You know, when are we, this is a pretrial conference here. Have you had a negotiation?
No, we had a negotiation day. He was representing himself. I came out here and looked for him. I didn't see him, so.
I come up here, whatever, but my daughter, she got put on the COVID or whatever. I showed up downstairs or whatever, because I called up there and asked them what I needed to do, and they couldn't nobody give me no answers. And I showed up downstairs and they stopped me down there and told me to just go back home.
Yeah, that is correct. He was sent home. I didn't see him. I didn't know that was happening. It happened. Nobody told me.
We would just ask for a negotiation day, pretrial conference, and
29th and the 5th, but now the issue of his freedom was here. If I'm a month in advance might be beyond his means. I'm gonna ask you to catch it up and you pay 10 days in advance every time. And when that 10th day comes up, you will have that other 10 days paid or report to the jail. And if you don't report to the jail, you'll be guilty of absconding. You understand what I'm saying? Okay. So you're in the custody of the jailer until somebody goes and catches it up and pays 10 days in advance. Okay, now we had Ethan Wilson, did we? Ethan Wilson. 23 CR 0050. Are you Ethan Wilson?
Yes.
We have a pretrial conference here. What's the story? Shocking.
I understand, please.
we have group.
Born in 2002. Last four digits, social security number 7254. Is this a diversion or?
It is, Your Honor.
A motion's been tendered, sir, that Mr. Ethan Wilson says you wish to enter a guilty plea. Is that correct?
Yeah.
Are you currently under the influence of drugs or alcohol? Is plea freely and voluntarily given?
Yes.
Are you the same person named in indictment number 23 CR 0058?
Yes, sir.
Have you discussed this matter with your attorney and are you fully satisfied?
Yes, sir.
You view the evidence the Commonwealth has against you, believe you're fully informed. Like you're fully informed, you understand that you do not have to enter a guilty plea today. You have certain rights under Kentucky and United States Constitution. Before I accept the plea, I need to know that you understand Stand those rights. You have a right not to testify against yourself. No one can make you say anything. Right to speak trial by jury. Right to be represented in the counsel at your jury trial. Right to confront and cross-examine all witnesses called to testify against you. Right to produce evidence. Right to call witnesses in favor. Right to appeal this matter higher court if you lose. Right to apply the comma without a reasonable doubt that you're guilty of charges against you. Understand that being a guilty plea, you give up those charges. Now, I may consider the Commonwealth's recommendation. I may apply any range of sentence allowed by law. I don't have to accept the recommendation. In the event that I do not accept the recommendation of the Commonwealth, you have and decide to impose a harsh sentence. You have a right to withdraw your plea and proceed to trial. Have you previously been diverted in the last 5 years? Have you had a pretrial diversion in the last 5 years? Have you had any felonies in the past 10 years?
No.
Are you on probation?
No.
You understand that if you fully complete the diversion program, that the charges will be dismissed pre-trial diverted. You understand that?
Yes, sir.
If you don't complete the diversion program, you understand that you come back before the court. If I revoke your diversion, a pre-sentence investigation report will be ordered and you'll be sentenced to be a convicted felon that can be used against you in the future. You understand that?
Yes.
Ms. Anderson, will you proceed to say what the Commonwealth's recommendation is?
Yes, Your Honor. Upon a plea of guilty to possession of controlled substance, first degree methamphetamine, the defendant shall receive a sentence of 3 years, pretrial diverted for 5 years. Diversion is to be inactively supervised, or unsupervised. The defendant agrees to enroll and complete the Cumberland County Specialty Court. The defendant shall obtain gainful employment or do 30 hours per week community service until gainful employment is obtained. The defendant agrees to have any and all drug paraphernalia and contraband disposed of in accordance with the laws of the Commonwealth of Kentucky.
So what you agree to?
Yes.
Is that your signature on the docket?
Yes, sir.
And the agreement? Your name on the docket is Ethan Wilson. What is your full name?
Do what?
What is your full name?
Ethan Preston Wilson.
Okay, and you were born in 2002.
Yes, sir.
Well, I'll accept the agreement. Now there wasn't a DUI in that, was it? It was just there's no DUI.
No DUI.
Okay. You'll meet with the probation, you're unsupervised, but you need to meet with the probation parole officer there. And it was total fine and court cost. You need some time to pay the $250?
Yes, sir.
Okay, you pay it to $30 in 30 days and $30 every 30 days after that, you pay $250. Okay. You're not going to door back there and get Mr. Cross. Yeah.
He told Mr. Cross that he was in court. He said, I can't come right now.
Bourbon County. Commonwealth of Kentucky versus Kenneth Neal, 23 CR 0025. Mr. Neal, you born in 1978. I think your microphone needs to be turned on there. Well, can you help him hit the icon there and turn the microphone on? Thank you so much. That's good there.
1978, yes, sir.
Last 4 digits, your social security number 4427.
4427, yes, sir.
Now, do you have an attorney in this case?
Not that I'm aware of.
Are you a state prisoner?
Not yet.
That's what. Okay, the Office of Public Advocacy represents you in district court. I'm going to continue that appointment. This is your attorney, Mr. Pennington here. You have the right to remain silent during your arraignment. If you have any questions, Mr. Pennington will contact you immediately and ask. So the grand jury of Cumberland County has indicted you and charged you with possession of controlled substances, first degree methamphetamine, and possession of drug paraphernalia, as well as failure to signal and failure to have a seatbelt. You understand those charges?
Yes, sir.
Yeah, I'm gonna sign a reciprocal discovery order and have the Commonwealth to give you all the evidence they have against you so you can prepare for your case.
Yes, sir.
I'm gonna set a negotiation day for you on September the 29th, and your court date here is on October the 5th. I don't know what your incarceration situation up there is, but your attorney will be in contact with you to see if we need to do a transportation order or what we need to do.
I'm finished here.
You are? Okay.
I'm waiting for you to come get me.
Well, you'll be waiting a while if you wait for me to come and get you, but
Not you, sir. No, not you, sir.
I'll send somebody up there, or we'll have you transfer back down. Okay, thank you very much. Bourbon County, thank you for your cooperation. We'll try to get this gentleman transferred back down as soon as we can.
Can I get the phone number to the my attorney?
I'll be in touch, sir. He'll be in contact with you.
Okay. All right.
Be in contact with you. Thank you very much, Bourbon County.
Thank you.
Thank you all.
Carroll County, are you on there? If we ever get Carroll County. And so we're, Mr. Cross, are you ready?
No, Your Honor, I'm still in the midst. I still have to report to the court. It's going to be a few minutes, if that's all right. Sorry. Thank you.
Okay, do we have anybody here in the courtroom that hasn't come up yet? I think that's, except for Mr. Cross, who's the exception. We're ready to go to Adair County. Adair County. Yeah, we'll be with Adair County in just a second. Mr. O'Donnell is here. Is Mr. O'Donnell here?
Yeah.
Okay. We got two hearings for him. One of them will be done here and one of them will take a short break and do one somewhere else. Mr. Donna, you come around here. Council, y'all move to your left. Move to your left here and I'll let Mr. O'Donnell there. Mr. Donald, are you Thomas O'Donnell? I am. Born in 1961. Last four digits, social security number 6773.
Correct.
You're here today in 22 CR 00103. A motion for discovery and inspection has been filed by your counsel, which requests significant additional discovery be provided by the Commonwealth and inspection of certain documents. I've reviewed the motion in detail, which was rather lengthy and in detail. What is the Commonwealth's response?
As regards that motion, I also have a motion, and part of my motion is included, I think, in this.
You need to speak up just a little.
Okay. In addition to that motion, I filed a motion to give the TBI notice that if they wanted to object to me releasing the TBI file to counsel for the defendant, they could be here and make an appearance. I've not heard from them, so I'm going to ask the court to enter an order so I can release that file to defense counsel. The reason I did that, when I got the file, there was a letter attached basically said that they had a proprietary interest and it shouldn't be released. So I wanted to give them an opportunity to object if they wanted to. And that will cure part of their motion by releasing it. Okay, well, whenever, if I don't hear from
notice for what?
Next motion.
Or was it?
It is, we just bring it to your time.
Okay, okay. Well, so I won't be able to release that file till 10/5.
Well, I'll hold that into that portion of the motion in abeyance.
Okay.
Do you have any objection to the rest of the motion?
I would ask for about 45 days to respond in writing. A lot of the motion is housekeeping. It was filed Friday. A lot of it is I'm going to have to go back and look at the nomenclature and identify what they're requesting because they're using a lot of numbers in this, and I'll have to be familiarized with
Okay,
that.
I'll give you 45 days and then.
Yeah.
The
only thing that concerns me is some of these items they went from Tennessee. I have no jurisdiction in Tennessee, but to compel somebody to provide that.
That's what you'll respond.
Yes.
So they'll be put on notice that they'll have to take some other action to get our sister state to offer that up. Or at least they'll know that you don't have it and can't get it.
If I
That
can.
and you've requested it, and probably ought to show them any kind of written request you've made to those agencies for them to provide that to you, any denial, and they'll know how to proceed. Is there anything else in your motion, this motion that we need to deal with?
Judge, I think 45 days for a written response is okay. A lot of the stuff from Tennessee, there were KSP officers documenting these things in the reports, working directly with individuals from Tennessee. So I think in terms of the Commonwealth exercising its due diligence to have those representatives of KSP go to those outside agencies that they work with directly to request those items and see if we can get it that way. I don't really know whether KSP has any obligation at this point. I think the Commonwealth Attorney's Office can request from KSP, but I think direct communication with the police agencies down there is what usually happens once it's turned over to the Commonwealth Attorney and his detective people.
And I'll have to contact the agency directly or contact the DA's office in that jurisdiction. And like I'm talking about videos they're requesting of Julie Harding, which they may be they're requesting videos when Julie Harding was arrested by the officers in Tennessee that may be discoverable, may not be relevant at trial, but something like that's what I'm talking about that I can't.
The only thing you can do is do a written request to them and then file a response. And I would ask to keep it in a timely sort of manner. It's when you do the request, as soon as you get a response denying that, then forward it to defense counsel then, so we won't wait on individual items till the 45 days. You know, you can kind of do a checklist and mark them off, and that way we'll kind of have a continuing discovery situation.
Maybe it won't be a problem. I hope it's not.
Yeah, okay.
So we'll have 45 days, a written response as to each item, and then if there's anything else.
Unless there's an item that's been denied and Commonwealth receives notice that they're not going to provide it, I'm asking them to go ahead and give me notice prior to that as soon as he gets the notice that they're not going to provide that. So you can start taking a look when we come back here on the 45 days. Let's just make that a date.
We could do the latter October date, I think.
Yeah, we've got a October the 26th date. October the 26th.
That would be fine.
Okay. And then on October 26th, you will have had reported anything that are refused before then. If you have things that have been refused to the Commonwealth before then, if you have additional way we can remedy that, you can have those motions filed by the 26th and we pick up some time. I won't wait till the 26th to see if his responses are not sufficient to you.
Understood.
Okay. You want to give them your responses 10 days before the 26th, so that
I hope to have it done way before then.
Well, let's say 10 days before the 26th, and hope springs eternal.
And one note as to the TBI's proprietary interest in their file and that issue as to notice and any objection from them. I would say that Mr. O'Donnell's rights under the Constitution to effective assistance of counsel and his right to confrontation regarding that file would supersede any.
Well, we don't know they're going to turn it down yet. You'll get to argue that if they turn it down. You know, we'll do everything we can to make sure. And if at some juncture you want to, I'll issue a subpoena ducis tecum and we can go through the process as you do with sister states to try to compel the attendance of someone if we get to that point. We're not there yet. I'm sure that, I doubt very seriously that they'll deny access to that. I wouldn't see why.
I'll be surprised.
Because if that happens and they get up here, as they say, the cup will pass from them as far as prosecution of anything that happened in Tennessee versus here. Do you have anything else? Will you attempt to draw an order and send it to Mr. Stockton?
Yes.
It complies with the thing. Now we're going to have a short break right now to let everybody kind of take a breath, and we'll go downstairs with your client for it.
We had a couple additional issues.
Okay, go ahead. If you get behind the microphone.
First, Your Honor, we've addressed the issue of the truck that's being held by the FBI in California in front of the court a couple of times now. Since the last time we were here, we did enter an agreed order stipulating to chain of custody so that the truck can be brought from California to KSP here in Columbia or in Columbia. So I brought another copy of the motion or the order for funds for
How much is it?
It is $1,750.
I got somebody to do it cheaper than that. Somebody told me they do it cheaper than that. No, that's fine.
Okay. Can I register?
Give it to the bailiff. Try to get the sheriff to go out there for $500, but he didn't much want to. I'll sign this order. Now it's going to be, I understand as to the agreement, it will be transferred, taken to the KSP lot in the post, the Columbia post. Is that right?
That's my understanding.
Yes, if you'll just tell me when it's going to be transported so I can remind them it's on the way.
I can do that.
Yes.
Okay, the order is entered. Okay, what else do you have?
The only other issue, we filed a motion for bill of particulars, I think at the last hearing date. And I thought Mr. Stockton was going to respond in writing, but I wasn't sure regarding the aggravator and the facts supporting it.
I would object to that because I've probably filed the most detailed notice of death penalty in the history of the Commonwealth of Kentucky. And I put all the facts in there. If there's something specific, but I just don't want to, I've filed everything I think I have on it at this point in time.
And Judge, as to that motion, when we were referencing the statute, we were looking for specificity.
Your laptop is blocking the microphone. And if you'll stand toward the microphone and speak directly into the good.
We were looking for specificity as to which specific theory the Commonwealth was pursuing under the murder for hire aggravator, because it could be either some kind of financial benefit, monetary benefit, or any other profit. So we were looking for information as to that theory. And then we were looking for the Commonwealth has to notice what specific evidence they're relying on in terms of what they intend to present to support the aggravator specifically. And the notice was very detailed as to what they intend to introduce to support a murder conviction. But when it comes to any evidence of funds received by Mr. O'Donnell or evidence pertaining to some other profit or benefit received or extended to him by Julie Harding, that's the kind of information we're looking for as to the aggravator.
Well, it's all in my notice. The way I see the case is the murder itself is a direct evidence case. The murder for hire is a circumstantial evidence case. And I have put all the circumstances in my notice for death penalty case as regards money. I put in the fact that all the money that Ms. Harding withdrew from the banks in Tennessee. I put in there that Mr. O'Donnell was paying $3,000 a month for a rental in Napa Valley for several months. And the next month he's trying to borrow $100 off his one of his co-defendants in order to get by. So that's circumstantial. I've got in there.
So you stand on what you've offered?
I stand on what I've got. If there's additional things as we're getting ready for trial, I'll furnish that as it's received. If there's something I've not put in there that I'm talking about, I'll do that. But I think I put all the circumstances I can
What
put
they're
in the
saying
notice.
is that on this particular aspect of the aggravator, that they need detailed information before the trial as soon as you get it, but the only thing that you can give is what you're relying upon now. If any time, I don't know in one of these situations, if there comes a time beforehand that you think that the aggravator is not sufficient, that you file a motion to knock the aggravator, say it's not sufficient before we proceed, then you can do that. Is there any time limit before a trial to do that under the statute, you think?
No, Judge.
I don't think there is either. So what he's saying is he's giving you all he has now, and he's under a continuing obligation to provide you discovery concerning the aggravator. You have me directed, my mind is directed toward the aggravator because of your motion. Okay, so we all understand what that's about. Okay, is there anything else?
So Judge, just to be clear, in terms of KRS 532.0251A, which is the statute dealing with the notice of what's being used in support of aggravation, the evidence contained in the original death penalty notice is at this point, the evidence that the Commonwealth will be relying on.
And I may glean some more evidence going through this lengthy discovery request. If I do, I'll furnish it.
He stands on that at this point, subject to this obligation to provide you with any additional information upon which he's going, or facts which he's going to rely. And if it gets to the point where you feel like that you haven't had that information provided to you in a sufficient time and a continuance is needed for you to do additional investigation, the court will be liberal in doing that. So
And then
won't be surprises on that. Okay.
And as to the theory that the Commonwealth is operating under, is, for the record, the theory would be that the aggravating circumstance is premised upon the offender receiving money,
Well,
as opposed to.
I don't want to, I will say this, one is money. It could be more than money. One of the witnesses I'll subpoena for trial will be a hostile witness. She's made statements about Mr. O'Donnell's and Miss Harding's relationship. So it may be more than that, but I think I'm entitled to go under any theory. And I can't, when I'm dealing with a hostile witness, I don't know what testimony she's going to provide on the stand. As regards any personal relationship between Mr. O'Donnell and Miss Harding.
And Judge, I think that's what the motion is.
So I think I can proceed under all the theories myself. I don't think I have to just choose one exclusively.
And I think that's fair, and that's kind of what we are looking for in terms of documentation in writing. Well, it may be the purpose of the offender receiving money using this circumstantial evidence, or in terms of this witness, it may be this theory in terms of the element of 4 other
Read the
profit.
statute that you're liable.
The statute.
Go ahead.
In terms of the.
Well, what you're relying this motion on about him disclosing which particular theory that he's proceeding under. I want to see the portion of the statute. I'm not familiar with the requirement of him giving a specific theory. Read me that portion of the statute.
So KRS 532.0251A says that the Commonwealth in the penalty phase may present only such evidence in aggravation as the state has made known to the defendant prior to his trial.
Okay. So are we still prior to the trial? Now we're prior to the trial, aren't we?
And so, and that's why we're requesting.
And I will guarantee you that he will give you that prior to the trial.
Well, the lady I'm referring to, she knows about in discovery, knows what that person has said.
Well, only thing you can give him is what you know.
That's
That's
correct.
So he's under a continuing obligation to provide you this prior to the trial, but I kind of, trying to get it a little sooner than that, so we don't have to get.
If I could take
Is there anything else that would say that the statute says he has to provide it to you in the next 35 days?
Judge, I mean, a part of it is this specific evidence that would be presented in the penalty phase to support the aggravating circumstance.
Before the trial.
Right, and the other part of it is just generally the case law associated with a bill of particulars requiring us to be provided with the information necessary to have sufficient notice of what it is we're defending. And there may be a difference in terms of us defending the receipt of something for monetary, the receipt of something associated with monetary value versus the receipt of something for other profit, or what for other profit even means in terms of, let's say, for example, this hostile witness and what the Commonwealth is thinking they may get out of her.
So what we're beating around is there could have been state, there could have been monetary things or personal things.
Right, if that's their theory, and
Well, I don't know, I don't know what their theory is at this juncture, but they're gonna give you.
But we're definitely gonna pursue the monetary.
Yeah.
And I don't know as far as the other yet.
Okay. Well, they'll give you notice of that before the trial, sufficient time before the trial.
Judge, if we were to tender an order concerning more detailed information regarding the aggravating circumstance,
He's under no obligation to give you that right now if he doesn't have it, or to speculate. He might not be finished. He might have a belief. He can tell you it's his belief in that, and he's developing it. So when he gets it, he's got to give it to you. The statute you read says before the trial, and I'll give you a little bit more before the trial and enough time to allow you to prepare a defense for it.
I understand, Judge. That's
all I can say. Okay, and what else do you have?
I think in terms of, I think that's it.
Okay, we'll take a short recess and we'll go down to the small courtroom for another hearing in this case. We're off the record for a few minutes, and Adair County will be back with you in just a minute. Thank you. Oh.
What's up, man? Stay busy. Always. Don't take this guy next year.
I appreciate
Yeah, I'll see. No.
Crazy.
You just give them the right. You do a fine job.
Yeah, it won't be long. He don't break much.
It shouldn't take that, it should have it in, like sometime I've been here.
No, he won't.
I just got the key, I hope he did, yeah, I ain't.
Yeah, he did.
They had to get it, they went back and get it.
Yeah, he had to have it. Just got that one, I wish it was another one.
He's been messed up all.
We're gonna get that today, I believe.
Year, 4 months. You got 2 more years. That's say like that. If it goes by like this year. Better believe it. I wish. I've got to be a magistrate. Yeah, you ain't got no. I'm not doing that. Call off. I done that a lot of years. I swore I'd never carry another patient. I remember a lot of times, but he had phones ringing at 3 o'clock in the morning. Not anymore. We teach you, and it teach you on the mixed up all that, but you hate it. Oh, yes, I've got one. It messes you. I want it. I need to sleep. He loses meals at certain times. You know, you look to try to help yourself. You can't do it. No. Long nights I go to bed as soon as I get home. I go to bed. Oh, I know. I bet. Yeah. Pray that thing don't go off. Yeah. You got any help out? You ain't got any? Yeah, I've got, well, out of the day, I'm in good shape of days, but of the nights for them weekend. Oh, okay. Yeah, the nights for them. Well, I struggle with it. Well, I ain't got none. Well, Stacy them more. I mean, Ken them well. Well, Stockton, he said he did. He said he takes that at school. That's school job. Oh, really? Ankle mold. Oh, just yeah, one is going to take that. Absolutely, it's got something. I was just sitting there thinking that something. Yeah. This is what you're talking about. It's just nice. If I would, They don't want to say anything, we're down, and he's on that. I forget somebody was there. I did, I heard that from somebody else. She screwed up. He just left. He just left, she knew it. Yeah. She wanted somebody to be sure. That's bad, pretty nutshell, that's it.
He just wants to.
Yeah, he was.
So I could fill my time too. So, oh, yes.
We got some loose take that off. Okay, Adair County, Timothy Alexander.
Can you hear me?
Yep, we can't see you. Turn your camera on.
Well, okay, there it goes. Okay.
Commonwealth versus Timothy Alexander, 19 CR 0042, pretrial diversion revocation, and 23 CR 0039, pretrial conference. What's the Commonwealth have?
We would like to set a trial date, but we've not been able to get the medical records from Skyline yet in Nashville. That's the problem. Furnish Mr. Poindexter. Then the injuries the victim received.
And Your Honor, we're asking, because it's no fault of my client, if the court would consider letting him out on a surety bond with an ankle bracelet. He's a member of the community that has never missed any court dates, never gone anywhere else to live.
What medical records are we waiting?
The victim in the assault case, I don't know that it's disputed. Mr. Alexander hit him with some type of sword or object and cut him across the forehead. He's got a big scar right there. And we're trying to get the records. He had to be taken to Skyline for this to be.
You can set a bond reduction motion if you want to. I'm not going to just do it on the spur of the moment like this. So you can set a bond reduction motion. You don't have to wait until the next rule date.
Yes, Your Honor.
You know, but I'm just not going to make one without, I have no knowledge of the case except what he said or his criminal background or his dependency. So I won't overrule it and I won't use this as, he hadn't had a bond reduction motion yet, had he?
No.
Okay, well, he's entitled to at least one, so.
Yes, sir.
You need to take it, make sure. So you set that. When do you think you're going to get those records?
Well, we first sent it, they denied the request, and we've sent it back and they've not. So we're hoping pretty quick. We'll check on it next week and try to find out.
Okay, well, let's set this case back for October the 26th. Okay? October the 26th. Hey, have you done any negotiations in this case or anything?
Or next time, let's try.
Well, yeah, I mean, once we get those records, I mean, we could try to negotiate it out.
Well, if he gets the records, we can set a trial by agreement before then. Okay? Okay, thank you. Crystal Ashcraft. Commonwealth versus Crystal Ashcraft. 23 CR 0069. Crystal Ashcraft. Is that your name, Crystal?
Yes, sir.
You were born in 1979.
Yes.
The last four digits, social security number 5007.
Yes.
Okay. We're on a pretrial conference. What do you got?
This is a random shot.
Okay. Who represents you, Ms. Ashcraft? Didn't have anybody listed. Do you have an attorney?
Perkins.
Department of Public Advocacy represents you in district.
Yes.
Y'all continue that appointment. You have a right to remain silent. Your attorney is here present, Mr. James Pennington. Say something, Mr. Pennington, so you're.
Hello, can you hear me?
Yeah.
Yes.
I don't know why he's not coming up on the photo.
Hello?
Okay. The grand jury, you have a right to remain silent, man. The grand jury of Cumberland County has returned an indictment charged with possession of controlled substance, first degree. Possession of controlled substance to first degree. Possession of drug paraphernalia. You understand those charges?
Yes, sir.
Counselor, do you acknowledge the identity of your client received indictment away from holding and arraignment, interplea not guilty, reserving all pretrial motions?
Yes, Your Honor.
Okay, let's set a negotiation date on this thing for September 29th, and the next court appearance is October 5th.
It's October 5th.
October the 5th, September the 29th for negotiations, and October the 5th for the next court date. Is that right? Yeah. Okay, thank you very much. Angela Branham. Angela Branham. Commonwealth versus Angela Branham. 23 CR 0052. Are you Angela Branham?
I am.
You born in 1973? You born in 1973, Miss Branham?
Yes, sir. Yes.
The last four digits of social security number are 1859.
Yes.
Okay, we're here today for a pretrial conference. What does the Commonwealth have to announce?
I don't have anything to announce. So we made an offer. I don't know what the status is.
And Judge, just to give the court Commonwealth status, the Commonwealth offered a specialty court referral. Ms. Branham would be eligible next rule day, almost 5 years to the date. She was discharged from drug court, I want to say out of Clinton County, but to qualify, and I don't want to send a referral up now and it get booted down when if we send the referral up next roll day, it would otherwise be within the period.
I'm willing to have her say it. She wants to do it.
Well, let's, what he's saying is she gets assessed now. She won't get.
Yeah, she's going.
Yeah, I guess that's the question. We're going to keep her in jail, I guess is the question. And for another couple of months. Yeah.
That'd be her advantage to stay up there.
Okay.
Okay, we'll continue this case till October.
Referral on the 5th.
Yeah, will the 5th be all right on the date? We okay on the 5th?
I'm fine with that.
Will the date be expired on the 5th?
Yes.
Okay,
It was
we'll
a September.
schedule this for October the 5th. October the 5th. That way you might get sent to be eligible for drug court.
Okay. All right. Thank you.
Hammer. Arraignment. Commonwealth versus David Hammer. 23 CR 0027. Mr. Hammer, were you born in 1987? Mr. Hammer, can you hear me?
Sir.
You born in 1987?
Sir.
The last four digits of social security number 2513.
Sir.
We're here today for the purpose of arraignment. Your attorney, Mr. Pennington, is here.
And Judge, just as a point of order, this is one where.
You need to speak up a little bit.
This is one where we will be needing a conflict counsel. This is the conflict with Shawandra Warren, I believe.
I'm going to arraign him first.
Yes, Your Honor.
You have a right to remain silent. The grand jury of Cumberland County has returned an indictment charging you, Mr. Hammer, with trafficking controlled substance, first offense, possession of drug paraphernalia, operating under influence, license in possession, not license, not in possession, reckless driving, and PFO on the possession case. Counselor, you acknowledge the identity of your client received indictment, waive formal reading and arraignment. Enter plea is not guilty.
Yes, Your Honor.
We'll do a negotiation date on the 29th and next court appearance on the 5th.
Yes, Your Honor.
All right, can I get like a 10% on my bond?
What is this bond? You have to have a bond reduction hearing. And your attorney will be up to talk to you about that, and he can negotiate that with the Commonwealth. They can't reach an agreement. I'll set you a bond hearing before then, okay?
Thank you, sir.
Lance Humphrey. Lance Humphrey. Commonwealth of Kentucky versus Lance Humphrey. Are you Lance Humphrey?
Yes.
Born in 1996?
Yes, sir.
Last four digits of your social security number are 5319.
Yes, sir.
You were here on a 21 CR 0018 on a probation revocation and 22 CR 0057 on a pretrial conference. Was a Commonwealth?
Your Honor, this case has been going on for some time because we had to wait on a KCPC evaluation. He was found competent in that evaluation. We had a hearing. He was found competent by the court. And about the time that was done, we had to change over to Mr. Pennington from Ms. Costello. So we probably need another pretrial to see if we can resolve this case or need a trial date.
Okay, let's have a negotiation date on September 29th. The next court date's on October the 5th.
Yes, Your Honor.
Okay, he'll be up, your new lawyer will be up to see you, Mr. J. Jones, J. Jones. Commonwealth versus Jade Jones, 23 CR 0053. Are you Jade Jones? You was born in 2002?
Sir.
You have to speak up, Ms. Jones,
Yes, sir.
because it's a voice activated microphone thing. The last four digits, social security number 7722.
Yes.
You're on a trial conference. What do you have?
Your Honor, this is a case where we just received the lab back and I think we just sent it to Mr. Pennington, so we'll need a negotiation date.
Negotiation day on September 29th. Next court days on October the 5th.
Yes, Your Honor.
Have you talked to Ms. Jones yet?
I have not, Judge. This was one where
Ms. Jones, your attorney will be up and talk to you in the next couple of days, explain to you what's going on here. They've got the drug test results back. He'll bring you the results up and talk to you about it, okay?
All right. Can I have her bond reduction? Okay, thank you. All right, thank you.
Wait just a second. It was just $10,000 surety to be signed by your stepfather. Clerk approved, you can come in and sign it and walk.
I'm not able to get a hold of my stepfather. Could I have it changed?
Or do you have somebody else who can make, who is your stepfather?
He's not my stepfather anymore. The person that
It used to be, so I will do a 10,000 clerk approved surety. Somebody in here, and then you'll be on a curfew. Okay, wherever you live, are you a Kentuckian? You live
No.
in, you don't live in Kentucky? Do you live in Kentucky?
No.
Okay, well then you got an issue as far as an out-of-state situation. You'll have to have somebody in Kentucky to sign it for a waiver of extradition. So it's not that long. Probably best you just stay there and we'll get to your attorney to come up and talk to you, okay? Thank you. Tang Lu.
You're good. Yeah, no.
Tang Lu.
She's already signed her waiver.
Okay, that'll be fine then. Thank you.
Thank you.
How do you pronounce your name, sir? Huh?
Tang Lu.
Tang Lu, that's what I said. Okay, thank you. This is 23 CR 0041. Sir, were you born in 1994?
Yes, sir.
Four digit social security number are 4231. We're here on a pretrial conference. What does the Commonwealth have to say?
Your Honor, he's represented, I guess, by Mr. Pennington on this case, and his co-defendant, Mr. Thomas. Sean Thomas is represented by Mr. Wilkinson, and I don't know if they needed any additional time, if they're ready to set a trial date in this case. I've made an offer, but I've not gotten a response. I know Mr. Pennington's new.
Two co-defendants or three?
Two defendants total.
And Judge, I just received this case about 2 weeks ago. I have had a chance to speak with Mr. Liu. I've not had a chance to speak with co-counsel.
You have Sean Thomas.
That's correct.
So what do you want to do? Set up a
I'm willing to do one more pretrial conference if they want.
Negotiation in this case is on September 29th. The next court date for pretrial conference is October 5th for Mr. Tang Lu, and we'll set a trial date if there's not an agreement. And let me have you bring, while we're here on this thing, to bring Clayshawn Thomas up. Clayshawn Thomas.
We had a conflict with them two being in here at the same time.
Well, I'll just wait till I get down to that then. So this gentleman can go, Mr. Liu, and your attorney will be up to speak to you. Charles McCoy. Charles McCoy. Commonwealth versus Charles McCoy. 22 CR 0044.
Yes.
Mr. McCoy, you were born in 1965.
Yes.
Last four digits, social security number 1873, correct?
Pardon me?
Commonwealth have to say.
Your Honor, he was found incompetent by KCPC in this case.
Yes.
And I have filed a petition for involuntary commitment under KRS 2028.
Yes, Your Honor, and we agree to the incompetency finding. I think at this point, he would need to have a guardian ad litem appointed to represent him in the 202A proceeding that could represent best interest. They would have to be a separate attorney from myself. It would have to be somebody appointed.
Your Honor, may I speak?
Wait just a second. I'm going to appoint a guardian ad litem.
Okay, thank you, Your Honor.
Charles, I've appointed you a special lawyer to come up and represent you on an involuntary hospitalization. They'll be up to see you in the next day or two, okay?
What now?
We're going to do a special hearing on you to see if they're going to hospitalize you to get you some treatment.
Yeah, I know. I had some Respiridol that I had a bad reaction to, and some Haldol. I'm getting where I can't control this one finger right here. As far as the feeling go, every once I want to do this right here a lot. See, Dr. Brown,
you'll have an attorney come up for the. You'll have an attorney to come up for the involuntary hospitalization. They'll be up to see.
They gave me some medicine. It must have been red flag.
Wait a second. Who's the attorney on that? Okay, well, Nick needs to be replaced by someone. He's the guardian ad litem in that one. And whoever, we'll just put a new guardian ad litem here, and you contact the district court to make sure they do that too, okay? In the same one.
I was gonna advise, I thought that there was a petition filed in district court. I thought there had been one filed in district court, but I wasn't sure the
There's been
status.
one filed in district court. We'll have one here. We'll have the same guardian ad litem. That way, Charlie, we'll get it going. They'll come up to see you, okay? Thank you very much. Thank you very much. Landon McIntyre.
See you.
Landon McIntyre.
Up here and see you, okay? Your lawyer will be up here to see you soon.
So I'll go back to my room now?
Yeah, you can go back to your room. Landon
McIntyre. Sentencing. Commonwealth versus Landon McIntyre. You are Landon McIntyre?
Yes, sir.
Born in 1993.
Sir.
Last four digits, social security number 8436. We're here today for sentencing. Mr. McIntyre, have you had an opportunity to look at the pre-sentence investigation report done by Probation and Parole?
Yes, sir.
Is it substantially correct?
Yes, sir.
Is there any reason why this gentleman should not be sentenced today?
No, Your Honor.
Upon plea of guilty possession of controlled substance, first degree, defendant shall receive a sentence of 3 years. He was previously pretrial diverted, and that was revoked. And on the operating motor vehicle, the same fines will stay in place. What were, have the court costs been paid in this case? All the court costs have been paid. There'll be no additional court costs. He previously entered and failed to complete the Cumberland County Drug Court and expelled from that. So it'll be 3 years. Okay, thank you very much. Now, the next person is Michael Nethery. Michael Nethery.
He's down at our Class D. They should be on.
Yeah, the Adair County Jailer at Class D. Michael Nethery, will you turn on Class D facility out there? Okay, let's go back to Raymond Oliver. If y'all will call out there and tell them to turn their camera on from the regional jail. Regional jail, if you want to come back on for Raymond Oliver. Commonwealth of Kentucky versus Raymond Oliver, 22 CR 00108. Are you Raymond Oliver?
Yes, sir.
Born in 1969.
Yes.
Last 4 digits, social security number 1975.
Yes.
We're here for pretrial conference. What do you have, Mr. Stockton?
Well, I've talked to Mr. Costello about this case and I've extended an offer, so I don't know where we're at.
Yes, Your Honor, we are currently negotiating, but we're also still waiting on DNA and phone dumps, but we didn't want to not be proactive while we are waiting on those because we do know that it takes a while. So we are negotiating the case actively while we wait for those to come back.
That's correct. We can't set a trial yet because of the DNA.
Well, I'll just put it back on so it won't drop through the cracks on October 26th, okay? October 26th. They're waiting for DNA results to come back for Mr. Oliver, so they can't set a trial date till then.
Okay.
So we'll do October 26th. Parker Purdue. Thank you. Parker Purdue. Commonwealth of Kentucky versus Parker Purdue, 22 CR 0061. Are you Parker Purdue?
Yes, sir.
You born in 1979?
Yes.
Last 4 digits of your social security number 3571.
Yes, sir.
Okay, Adair County Class D, will you turn your camera off just for a second and we'll get right back to you.
Yes, sir.
Okay, what do we have on Parker Purdue, a probation revocation?
Judge,
That's correct.
this is a case that I withdrew from last month. You were considering letting me withdraw. You'd never said yes. I appeared here today just so that the record is clear, because he would need a public defender's office and they've not been appointed at this point.
He what?
He would probably need the public defender's office to represent him because he's indigent.
Whenever I'm ready to proceed today or whenever. He's not going.
He hadn't signed an affidavit or anything, I don't think. Has he signed an affidavit?
I don't know. He's been really busy lately, so he just absconded from his facility.
Yeah, I was gonna turn myself in Monday. That's what they told me to do, is turn myself into the probation and parole.
I was getting ready to say he only left August the 21st, so he's not been gone that long before he got picked up. I don't know how he could have signed an affidavit.
Well, I'll get him, we'll get an affidavit. You want a public defender, you can afford a lawyer now, is that right?
Yeah.
Did you feel like that you had paid Mr. Garrett to represent you all the way through this?
Yeah, I didn't pay him. Mom and Dad paid him.
Yeah. Yeah. Mr. Garrett.
Judge.
Okay, well, I'll let Mr. Garrett go reluctantly. Yeah. And the public advocate will be up to meet with you, okay? Public defender. Let's go back. Who is it that we had out there?
Michael Nethery, Your Honor.
I'm Mark Food. Commonwealth versus Michael Nethery. Can you hear me, Mr. Nethery? The microphone's off there. Thank you.
Okay, can you hear me now, Johnny?
Yeah, we can hear you. Commonwealth versus Michael Nethery, 22 CR 0020. Mr. Nethery, you born in 1964.
Yes, sir.
Last four digits, social security number 8105.
Yes, sir.
Okay, we're here on a motion for shock probation. Did you file this?
I did, Your Honor. It was filed by my office at my bequest in July when I was out of town for the training event. I think it was set over to today because the person.
Tell me about it.
Yes. So, Your Honor, Mr. Nethery was revoked back in January after some failed drug tests. He had relapsed after the death of his son. He has now served actually more than the 180 days, 173 at the date of filing. So it was filed timely. And we would just ask this court to please give him the opportunity to have another shot at probation. He did go through a terrible loss. He's now served quite a significant portion, with it being more than 180 days at this point. And he had credit for 130.
Besides the number of days, what you suggest going to happen to him when he gets out?
Your Honor, he has the opportunity for employment. I believe he has spoken to Mr. Junior with to help with landscaping and things like that. So he does have the opportunity for employment, Your Honor. He's in the right headspace. He's been working at the Class D facility and being productive with his time. He just wants another shot.
I received a letter that he had a job. Was it Watson Logging or a logging?
And it may be switched now that we're to the end of it.
Okay, that was the information I had.
Yes.
We're showing probation parole. He's got a 7-year, 6-month sentence. His total time served at this point is 11 months, 17 days. He's parole eligible in March of 24. And he had that 7-year sentence. He had about 5 grams of methamphetamine on him when he was caught. So it wasn't a tremendous amount in the days terms, I guess. So I would be willing, if he would go into drug court, I'd be willing and keep his employment, do that.
Do you think he's eligible for drug court?
Your Honor, I don't see why not. I don't think he's had it within the last 5 years.
Will try the drug court, Mr. Nethery?
Yes, sir. Yes, sir.
Well, I'll do a referral and hold this in abeyance.
Thank you, Your Honor.
I'll do a referral and have it assessed for drug court. And if you will do that, we'll give you a shot at that. Okay?
Okay, thank you.
Thank you. Dale Reasoner. Dale Reasoner.
Yes.
Commonwealth versus Dale Reasoner. 22 CR 0017. Gregory Shields represents you. Is that correct?
Just keep on motion on June 26th.
Mr. Shields withdrew from your case. Are you going to have another private attorney?
No, I need to get one appointed to me if I could.
Well, I'll appoint Office of Public Advocacy to stand in for arraignment until I get an affidavit. Y'all need to correct. Okay.
And Your Honor, I believe he was appointed to us on Tuesday in Adair County on another case.
Okay, it looks like it's appropriate. Okay, I'll appoint the Office of Public Advocacy. The grand jury of Cumberland County has returned an indictment charging you with receiving stolen property. You understand that charge. Mr. Bailiff?
Yes.
Okay. Do you acknowledge the identity of your client, received indictment, waive formal arraignment?
Yes.
You're pleaded not guilty, reserving offer, pre-trial motion for your client.
Yes, Your Honor.
We'll have a negotiation day on the 29th of September, and October 5th be the next court date. What's this gentleman's bond?
Your Honor, he was placed in NCIC in June of 22.
Okay, it's an NCIC, so it'll take a bond hearing. Okay, thank you, Mr. Reeser. Your attorney will be up to see you. Mr.
So is there any way I can get a bond deduction?
Well, you've been in NCIC all these years, and So your attorney's gonna have to come up and interview and then he can give some explanation to the Commonwealth and we'll take a look at it. Okay, I'm not saying no, I just don't know enough about it, okay?
All right.
Commonwealth versus John Scott. John Scott. Commonwealth versus John Scott, 23 CR 0045. Are you John Scott?
Yes, sir.
Born in 1962.
Yes, sir.
4-digit social security number 9063.
Yes, sir.
You're here today for the purpose of arraignment. Doesn't show you with an attorney on here. Do you have an attorney?
No, sir.
Can you afford an attorney?
No, sir.
Looks like we have an affidavit here.
Is there any way I could get back on my original bond?
Well, I'm taking a look at it right now here.
Oh, I'm sorry. I'm sorry.
No problem. Are you on a disability?
No, sir.
Where do you work?
I work for myself. I'm self-employed.
What do you do?
Bush hog. I run a bush hog in a little mechanic shop, and a bush hog job. Bush hogging. I don't know what, self-employed.
Yeah, I'm gonna appoint public advocacy to represent you, public defender to represent you. And we'll get it. It looks like you sufficient affidavit. You live in Salina, Tennessee?
Yes, sir.
No, well, that'll be a problem as far as your bond. You'll have to, what is the bond set at now?
It's a surety, it goes to 2,500 cash in this report. I don't know if it's been discharged or not.
Check, see the money's there. We'll check on the bond here in just a second.
Thank you very much.
Grand jury of Cumberland County has returned an indictment charging you with possession of controlled substance in the first degree, operating a motor vehicle under the influence. First offense with aggravating circumstance, possession of drug paraphernalia, driving on suspended license, failure to maintain insurance. Failure to signal. Nuisance. Obstructed windshield. Failure to use a seatbelt. Yeah, the bond, your bond was released at $2,500. Somebody came and got it. Did you come and get it, or?
I could range that.
No. Do you acknowledge the identity of your client, receiving an indictment, waive formal reading, arraignment, enter plea of not guilty, reserving all three trial motions?
Yes, Your Honor.
Was he just picked up on this warrant, or was
What happened was he was in district court, and then after he was indicted by the grand jury, I couldn't get him served, so I just wrote a letter to the Clay County Sheriff in Tennessee, and they picked him up because we had his address. So if he wants to do the $2,500 cash bond again, I've got no problem.
Bring a $2,500 cash bond back up here, and you get the connections here. You have to be up here again for negotiation. Don't drive up here. Have somebody to bring you.
Yes, sir.
September 29th and October the 5th is your next court date. Both of them are conditions of your bond. The public advocacy office will get your address out of here and get your phone number, and they'll be in contact with you. And I want as a condition, you feel compelled to come back to the state of Kentucky, except for court. You don't need to come up here except for court, do you?
No, but I will come.
Well, you come up here for court and stay out of Kentucky except for that, okay?
I'll do that.
Okay, thank you.
Thank you, sir.
Patrick Sharp. Patrick Sharp.
Have to wait.
Commonwealth versus Patrick Sharp, 19 CR 00113 114, 21 CR 0053, and 23 CR 0063. Are you Patrick Sharp?
Sir.
Were you born in 1996?
Sir.
Last four digits, social security number 4954.
Sir.
We're here today on two pretrial diversion revocations, a probation revocation, and a pretrial conference. What's the Commonwealth?
Your Honor, if Mr. Pennington wants a negotiation day so we can try to do a global settlement, I'll agree. I don't think he's probably been to see him yet.
Judge, no objection to that.
September the 29th is a negotiation day for you, sir, and your next court date is October 5th. Your public defender, your attorney here is going to meet with the Commonwealth attorney, and they're going to try to do a global settlement, get all your stuff together and take care of it next month, okay? But we got an earlier rule day next month, so you kind of lucked out on it. So they'll be on September the 29th and October the 5th, okay?
Is there any way I can get a bond reduction?
Well, your attorney will come interview you about that, and if he can give us a Commonwealth of it, we'll take a look at it. The attorney needs to become familiar with your case first, okay? Jason Sherrill.
We had to do work out.
Jason Sherrill. Jason Sherrill. Are you Jason Sherrill?
Yes, sir.
Sherrill, were you born in 1976?
Yes, sir.
Four digits, social security number 8694.
Sir.
We're here on 21 CR 0041 for a pretrial conference. You represent the Office of Public Advocacy. What does the Commonwealth have to say in this case?
Your Honor, this is a case involving two undercover buys. I've made an offer on the case. I don't know what the status is.
And Judge, I just got the case. I'm trying to look to see if I need to do a bill of particulars on this one, but I have been overseeing Mr. Sherrill. If we could just skip one more
Negotiation day on September 29th. Next court date, October the 5th. What's Mr. Sherrill's bond set? Okay, why is that? Is there a failure to appear or?
Well, it was because they were undercover buys.
Your attorney, once he gets familiar with your case, can negotiate with the Commonwealth about your bond. I'm not saying no to a bond reduction. I just don't know enough about it yet today, okay?
All right.
Very much. Jacob Smith. Commonwealth versus Jacob Smith, 23 CR 0032. Are you Jacob Smith?
Sir.
Born in 1987. Social security number 4054. We're here today on 23 CR 0032, a pretrial conference. What's the Commonwealth at?
Your Honor, this is one we've made an offer. We're waiting to hear back.
Judge, I just had a chance to meet with Mr. Smith. I understand he has some Casey County cases going on, so we're trying to look to see if we can get a global resolution to our charges.
September the 29th for a conference date, October 5th, next trial date. And they're going to go to the Casey County and see if they can get all your stuff wound up in one thing, sir.
Now, Judge, Mr. Smith does have a unique bond, but I have looked at it and, not necessarily asking the court to review it, but
He was out on bond.
The reason he's got a problem is he was out on bond when he got charged with this.
And Judge, he would be able to make a surety. He was offered a surety initially and it converted.
Well, that's what happened. We found out he was out on bond on that other case when he allegedly committed this case. So that it's not a good thing if it's true. So you negotiate with him and talk to Commonwealth. We might be able to advance this thing. Okay.
Yes, Your Honor.
Curtis Spears is next. Commonwealth versus Curtis Spears, 22 CR 0087 for probation revocation, and 23 CR 0066 for arraignment. Mr. Spears, is your birthday and year of birth rather in 1974?
Yes, sir.
And 4 digits, social security 1612. Your attorney here is the Office of Public Advocacy. You have a right to remain silent. The grand jury of Cumberland County has returned an indictment charging you with trafficking controlled substance over 2 grams. Possession of controlled substance, first degree methamphetamine, delivery, manufacture of drug paraphernalia. Driving on a suspended operator's license. Failure to maintain insurance. Improper display of registration plates, no registration receipt. Persistent felony penalties for traffic. Do you understand those charges? You understand the charges? I'm not asking where you did it or not. You just understand the charges. Okay. Counselor, you acknowledge the identity of Mr. Curtis received indictment, waive formal reading and arraignment, enter plea of not guilty.
Yes, Your Honor.
I'm going to reserve any action on the probation violation until you have an opportunity to negotiate the case. Negotiation date is set up on the 29th of September, and the court date's on October the 5th. Okay. Okay, Ellis Stearns. Ellis Stearns. Commonwealth versus Ellis Stearns, 23 CR 0034. Are you Ellis Stearns?
Yes.
Born in 1965?
Yes.
Last 4 digits, social security number 6792.
Yes.
Okay, you have a right to remain silent. You have a lawyer?
Supposed to have one from the court. I don't know what his name was.
Okay, well, that was in district court, and I'll continue that appointment. The grand jury of Cumberland County has returned an indictment charging you with possession of controlled substance, first degree methamphetamine, class D felony, endangering the welfare of a minor, 2 counts. Possession of controlled substance in the 2nd degree. Possession of drug paraphernalia. And failure to wear a seatbelt. Counselor, you acknowledge the identity of your client, receive indictment, waive formal reading and arraignment, enter plea of not guilty, reserving all pretrial motions.
Yes, Your Honor.
Yes. Okay, the negotiation day is on September 29th. October the 5th is the next court appearance. What is this lady's bond?
20,000 surety, but she owed 2,500 at 10% district court. And discharged because it was.
See what she's got.
He was suspended back. So it's still there.
So she got a $2,500, 10% bond. That's it. That's just $250. Where do you live, Miss Ellis Stearns?
I live in Somerset, Kentucky.
Somerset. What was it? Appearance district court. Yeah, I'll leave your bond the way it is, $2,500, 10%, because you did make your appearance in district court. Your next appearance here will be for a negotiation day on the 29th and then October 5th. Court date. Both of them are part of your bond. You understand that?
But can I reduce it? I need to go to the hospital. I'm trying to pass a kidney stone right now.
Well, I'm fixing to let you out of jail and you can pass the kidney stone anywhere you want to as soon as you do it. you know,
I'll be glad to get home to go to the hospital passage.
got somebody to come get you.
All I gotta do is when I get done, go call my boyfriend, he can come get me.
Well, I'm gonna keep the court dates that you gotta keep are September the 29th and October 5th, both of them here in Burkesville, okay?
See, the reason I couldn't make it the other time, we didn't have a vehicle, and I had to pay for get his vehicle
It's
fixed.
okay, listen, you're about to get out, so let's just keep on moving. You might
Alright.
see something to keep you in, so. Yeah, you need to stay at home. When you get back home, you need to accept work, church, doctor, or come to court, okay?
Okay.
Okay. Else, I guess you can have them sign that up there at the jail, those additional conditions. Okay, well, I hope you feel better, man. See you later.
All right,
Danny
thanks.
Stewart. Danny Stewart. Commonwealth versus Danny Stewart, 23 CR 0017. Are you Danny Stewart?
Yes, sir.
Were you born in 1973? Born in 1973, Mr. Stewart?
Yes, sir.
Your last four digits, social security number 5485.
Yes, sir.
Okay. What does the Commonwealth have on Mr. Danny Stewart?
Your Honor, we just got the lab back on that, so if we have another pre-trial.
Is he charged with possession?
Mhm.
Possession?
Yes.
Is there anything else with the possession?
No.
What's his bond say?
$15,000 surety. He just put it in there. Looks like. He might be on probation if he gets out.
You got anybody to sign a surety bond for you?
Yes, sir.
Okay. I'm gonna set you $15,000 surety bond. And you're on probation now, right?
Yes, sir.
Well, you follow the rules. And where do you live, Mr. Stewart?
I live in Grant County, Kentucky.
You know, you just stay out of Cumberland County until you come back to court. Unless
Yes,
you
sir.
need your attorney, okay?
Okay, sir.
Okay, thank you. We'll send some paperwork up there. You get somebody to make the bond for you.
All right, thank you.
Quayshawn Thomas, we handled earlier in the day, correct?
No, they didn't call him up because of the conflict.
Oh, yeah, that's right. Quayshawn Thomas. Quayshawn Thomas, 23 CR 0042. Are you Mr. Thomas? Okay, you born in 1997?
Yes, sir.
Last four digits, social security number 3952. You're represented by Conflict Counsel.
Yes.
Office of Public Advocacy. What does the Commonwealth have to say?
Your Honor, we set the co-defendant on September the 29th and October the 5th.
September 29th for negotiation, October 5th for the next court date. What's his bond at?
$10,000.
We need a bond hearing on him because of his criminal history. They were both charged with possession of a handgun and heroin, either or.
Okay, well, you can set a motion for bond reduction if you desire. And if not, we'll see him on October the 29th and September the 29th and October the 5th, okay? Thank you. Thank you, Mr. Thomas. Jason Thrasher. Commonwealth versus Jason Thrasher. This is 19 CR 0086 and 19 CR 0087, Commonwealth Kentucky versus Jason Thrasher. Mr. Thrasher, you were born in 1972.
Yes, sir.
Last four digits social security number are what?
7385.
You're on probation revocation. What does the Commonwealth have to say?
Your Honor, he has those two pending cases, and the basis for the revocation is 23F62, which went to the Cumberland County Grand Jury today. So I don't know if the court wants us to have a hearing, we can, or if he wants to try to wrap them all up, we'll try to do that.
And Judge, I'll just ask to pass and see if an indictment.
Did you get indicted today?
I think there was not any that there weren't any returns on, so I'm sure he was. It's a possession case.
it appears he has been indicted. I don't know what the charge is. We'll wrap your cases up on September the 29th for negotiation. We'll be back here on October the 5th. See if they can get all this wound up together. Okay, Jason?
All right, thank you, Your Honor.
Thank you. James Wilson. James Wilson. Are you James Wilson? Okay. Were you born in 1996? You have to speak up a little bit.
Yes.
Okay. Last four digits, social security number 1308.
Yes.
Okay, you're here on 23 CR 0043 for a pretrial conference. What's the Commonwealth have to say?
Your Honor, we don't have a resolution, and I didn't know who his attorney was. Has he been appointed an attorney?
Office of Public Advocacy. It says
Okay,
here.
the paperwork I had, couldn't think.
And Judge, we were just in a negotiation today.
What's he charged with?
Possession.
What's his bond?
15,000.
You just have a $15,000 surety. Anybody can come up and sign that here at the clerk's office, or that, you have anybody to make your bond for you?
No.
Well, are you from Cumberland County?
Yes.
Well, your attorney's gonna come back up there and interview you, and if you got any kind of indigency problems, but surely you just need to rack your brains, have somebody come up here, just an appearance bond. It doesn't mean that they guarantee your conduct or anything. You can get out, but you have.
So if somebody just comes to a clerk office and signs
They gotta be approved. They've got to show that they're worth $15,000. They to sign the bond. So, I mean, they can have a small house or a trailer or whatever. If they own it, they can come up and sign your bond, and it won't cost them anything. Isn't that right, Madam Clerk? $25 all it costs. Okay, we'll see on September 29th negotiation, October 5th is your next court date. If you make bond, you'll need to stay at home except for church work or doctor, okay? Come back. Thank you.
Thank you.
Okay, now, is there anyone else here on the criminal docket that we've skipped over? Not that it's been rather confusing.
We got Mr. Cross's case.
Mr. Cross, are you ready now, Mr. Cross?
Yes.
Keith Smith. Albert Wilson, also, and David Cross.
Keith Smith.
But you have Albert
Yeah,
Wilson
we have
also.
Albert Wilson as well, yeah.
Keith Smith first. Albert versus Keith Smith. Is this a motion to suppress? You want to call your first witness?
I do, Your Honor.
Okay. Who's your first witness?
Brandon Poole.
Raise your right hand. You swear the testimony about to give us the truth, the whole truth, and nothing but the truth.
I do.
Good. Proceed. Lean toward the red microphone and identify yourself, please.
State your name for the record.
Trooper Brandon Poole,
And how are you employed?
State Trooper at the Kentucky State Police Post 15,
And how long have you been employed there?
approximately 3 years.
And prior to that, did you work for any other law enforcement agency?
No, ma'am.
Did you have to go through any type of training to become a trooper?
I did. I went to Frankfurt for approximately 24 weeks.
And are you familiar with Keith Smith?
Yes, I am.
And did you stop him on November the 13th, 2022?
I did.
Here in Cumberland County, Kentucky?
Yes, ma'am.
All right, please tell the court how you came in contact with him and why you stopped him.
I observed Mr. Smith be operating a motor vehicle in Burkesville, Kentucky, near the public square. I ran the Kentucky registration plate through my agency issued MDT. The registration through Avis returned to show verified proof of insurance. That time I initiated traffic stop.
Now, what is Avis?
Avis is the automated vehicle information system associated with the transportation cabinet.
How often do you use that system?
I use that system every shift.
And did you receive any training on how to use it?
Yeah, we were trained in the academy, just on the basic, just our system and on entering the license plates and what they'll show as far as the returns and what's the returns mean to us.
Okay, so how do you use the system?
So for this scenario, I entered the license plate, registration number. You got to make sure it's the correct state. This would be Kentucky. And it'll show the registration status, the registered owner, and then it will also show the insurance indicator.
Okay, and as far as insurance indicator, what would the reading be?
For the state of Kentucky through Avis, it will, on insurance, can show three things. It'll show yes, it'll show verify approved, or it will show canceled registration plate for failure to maintain insurance.
Okay, and on this particular date with Mr. Smith, what did it show?
Verify approved of insurance.
And how many traffic stops have you made in the past 3 years that you've been a trooper?
I conduct approximately, let's say 10 to 20 traffic stops a shift.
And you said you use Avis every time before you even make a stop.
90% of my stops I'm using Avis, unless the circumstances are where, you know, I may be rushed or may not have any internet service or something.
In your experience, when you use Avis and it comes back verify, how often does someone not have insurance?
More than not.
Okay. If you could give a percentage.
A percentage, I would say approximately 75 to 80%.
And now, whenever you did make the stop on Mr. Smith, how did you proceed from there?
So I would say the other percentage at the time is me taking their word or them showing me a valid copy of the insurance. So it's not, even then, I wouldn't say I would be 100% sure to say that they have insurance. I'm just taking their word based on their proof that they show me.
Okay, so sometimes even though it says verify and they do in fact have a card, it may not be a valid insurance card.
It's a possibility.
And after you approached Mr. Smith, what happened then?
When I made initial contact with Mr. Smith and introduced who I was, who I worked for, and asked for his documents, at that time I immediately observed clues of possible drug use.
Okay, what were those clues?
I observed Mr. Smith. This was at night. I observed Mr. Smith to have dilated pupils. I was using my agency issued flashlight. His pupils had little to no reaction to light. As I was talking to Mr. Smith, I observed he had body tremors and eyelid tremors as well.
And this was all on the initial contact with him?
Initial contact is immediately.
Okay. Did you ask him about his insurance?
I did. When I asked him about his insurance and registration, he advised it to be in the glove box at that time. I'd shown my flashlight to his glove box. He was retrieving his documents, and he had handed me a Adair County quick lube service receipt.
Okay, so did you find that odd?
I did find that odd.
And why?
Because that's not what I was asking for.
Okay. Was it lit whenever you were shining your flashlight?
Yeah. So based off my training and experience, if anybody's going to be digging around in the vehicle, I'll always have my flashlight to where they're digging for safety reasons. And to assist them to look, but mainly for safety reasons, because I want to know what they're about to grab and what's in that area.
Did you ask him any type of questions where he was having to give responses to during this time?
Yeah, basic questions I recall asking just basically where he was coming from, where he was going and stuff.
And what kind of responses did he give to that?
Most of the questions I was asking about, I was having to repeat them over and over again as he wouldn't understand.
And based on all of that, what did you do from there?
Based off the clues and his demeanor, what I done from there is I felt the need to step him out of the vehicle and see if he could consent to standard field sobriety test. At that point, if I want to have someone do standard field sobriety test, for my safety and training, I want to make sure they don't have any weapons or anything on them. At that time, I'd ask Mr. Smith if he would consent to a search of his person and the entirety of his vehicle. Mr. Smith granted me consent of both. I had him step out of his vehicle at that time. We stepped to the back of the truck. And I don't remember if we dropped the tailgate if it was already down, but on the tailgate, I asked if he'd empty out his pockets. At that time, he began emptying out his pockets, and I was on his left side, and I observed him taking his right hand and shoving his fingers back down into his front right pocket. That time, I stepped around there and asked him what he was doing. I looked, and I could see it's like a part of a plastic baggie out of the small pocket behind the big pocket of his pants. And at that time, I reached in there and grabbed it and pulled it out, and it was a plastic baggie suspected methamphetamine at that time.
Did you locate anything in the vehicle?
Inside of the vehicle, there was a handgun in the center console.
After you located the baggie, what did you do next?
As soon as I located the baggie, at that time, detained Mr. Smith and read him his Miranda rights and started talking to him about the substance.
Did you make any statements about the substance?
He did. He advised it was methamphetamine, but he advised that he had just left Jimmy's fuel station here in Burkesville and he'd picked it up off the ground.
Did you conduct any field sobriety tests with him?
I did. I took the handcuffs back off him and done standard field sobriety tests on Mr. Smith.
Okay. And which test did you have him perform?
He performed HGN, the walk and turn, and the one leg stand.
How did he perform on the HGN?
HGN is based off 6 clues. He showed 4 of 6 clues on HGN.
Okay. And what about the walk and turn?
The walk and turn is based off 8 clues. He showed 5 of 8 clues on walk and turn.
And then the one leg stand?
4 of 4 clues on one leg stand.
After that, what did you do?
At that point, I placed Mr. Smith back in handcuffs, placed him under arrest. I transported him to the Cumberland County Hospital at that time.
Okay. And did you ask him to come to do a blood test?
I did. I read him implied consent. He did not wish to speak to an attorney, and he refused the blood draw.
Okay. At that point, did you seek a search warrant?
I did. Filled out an affidavit and search warrant at that time.
Okay. And do you recall what information you put in the affidavit?
Yes, as far as the affidavit goes, it was basically just the totality of the circumstances of the stop and what I observed on the initial contact, and then what I observed on the standard field sobriety test.
Can you tell the court exactly what you described in your affidavit?
So on the affidavit, one thing on the initial observations was how I had to repeat questions and comments as if he wasn't understanding what I was saying. He had I noted the difficulty he had in following instructions. On the HGN, I noted the 4 of 6 clues on the affidavit, and the 5 of 8 clues on walk and turn, the 4 of 4 on the wooden leg stand. I advised how the subject showed dilated pupils with no reaction to the presence of light, the body and eyelid tremors, and that the subject was in possession of a suspected methamphetamine.
And you also said that you listed his performance on the field sobriety test.
I did.
And based on your training, now, whenever you did go through your training, were you trained on DUI investigations?
Yes, we had a lot of training on DUI. We even done like sample labs. People came in and we actually physically done the test on people from the community. I think there was one whole week was specifically for DUI training.
And in your training and experience, did you believe Mr. Smith to be under the influence of a substance that night?
Yes, ma'am, I did.
Okay. And did you, based on the clues and just your interaction with him and what you found, what substance did you believe him to be under the influence of?
Methamphetamine.
Okay. And were you able to get the blood sample?
I was.
Do you know if it was sent off to the lab?
Yes, it was.
Do you know if those results have come back?
Yes, ma'am.
And what is the result?
The results from the lab showed methamphetamine to be in his blood.
I have no other questions of this witness.
Would you like to inquire, Mr. Cross?
I would. Well, unfortunately, this courtroom's gotten bigger and bigger as I've gotten older, so I'm going to have to go back over some things. I really couldn't hear Ms. Anderson very well at all. I heard you pretty good.
No problem.
I'm intrigued about this MDT. What is that stand for?
A mobile data terminal.
Okay. is that something that you have in your cruiser and you enter data and it reads out the owner, the registration and the three aspects of insurance, yes, no, or verified, right?
Yeah, that's a few things it shows, yes.
Okay. Now, is this something that we could look at if need be and determine how often that you use that? Is there a record, is there a log, is there an electronic log of that? Or do you know?
I don't know.
Okay. If
I
you
don't know.
That's fine. Okay. Because courts have upheld the stops based on normal usage of this, but my question to you now is, and I think you answered this.
Okay.
How often do you use this MDT during your shift?
Sir, I use it every shift, and actually a routine that I've gotten in and the way I was trained was before I pull out of my driveway, my MDT is ready to go, and I have this system pulled up always.
Okay. So how often do you use it? When you just see it, when you're sitting here in Burkesville and you meet a car or get behind a car, you automatically try to use it as often as you can, correctly?
Yes, sir.
Okay. So during the 8 hour, are your shifts 8 hours?
Allegedly 10.
Okay. So can you estimate how many times you might use it during a normal working shift?
Sir, it depends on what I'm doing that day.
Understand.
We have a lot of responsibilities as a state trooper, and not every day am I just routinely just doing traffic patrol. So I would hate to really put a number on it. I can say that I do use it every day, but as far as putting a number on it, it depends on exactly what I'm doing that day.
Respect that. That's fine. But you use it as often as you can, you said.
Yes, sir. If
Now,
I'm specifically working traffic,
here's my question too, is you enter that data and what percentage of the time does it come back either needs to verify or insurance cancel? If you can put a number on it. If you can't.
I wouldn't put a number on that.
Okay. Over half the time?
No, sir.
Okay, less than that.
Yes, sir.
Okay, all right. Now, let's talk about what happened after you stopped Mr. Smith. You stopped him to verify his insurance, correct?
That is correct.
And did you ask him to get out of the car or did he remain in the car when you stopped him?
On the initial approach, he was in the vehicle.
Yes, sir.
I exited my patrol car.
Right. Did you ask him to remain in his vehicle or did you ask him to get out?
At what point?
When you approached his vehicle.
We did not discuss him getting in or out of his vehicle on the initial approach.
Okay. What did you inquire of him when you approached his vehicle?
License, registration, insurance.
Did he hand you his license?
Yes, he did.
Did he hand you his registration?
I don't recall.
Did he hand you his insurance?
At one point, I think he did finally show proof of insurance, yes.
Well, when was that point, sir?
It was on the initial approach.
Okay, so at that point in time, he furnished you proof of insurance and he did have proof. You're satisfied with that. You didn't cite him for that, correct?
That's correct.
Okay. So at that point in time, the initial purpose of the stop had been completed, had it not?
Sir, that's correct, but I did not feel comfortable at the time based off what I observed for him to leave.
I understand what your subsequent observations were, but your testimony was this, that you approached him and asked for his license and his registration and his insurance, and he handed it to you, and you were satisfied with that, correct? How long did that take, sir?
It wasn't as quick and as simple as the way you're putting it.
Well, he sat in the car, right?
Yes, sir, he's in the vehicle.
Okay. And this was 11:13 at night. He complied with your requests, right?
No, I didn't have any issues with him, no.
Okay. You did say that he had dilated pupils. How were you able to detect dilated pupils if he was in his car and you were outside, sir?
Well, I'm standing there at his driver door, and I'm
Yes, sir.
standing right in front of his face, for one. And two, as I'm talking to him, based off my training, I will use my flashlight to shine him in his eyes as I'm talking to him.
Why were you doing that, sir?
Search part of my stop.
No, it's not, sir. I'm not trying to be argumentative, but your stop was for the purpose of seeing if he had insurance. So why were you shining your light in his eyes?
That is correct, but I remember seeing eyelid and body tremors at the initial contact.
Okay. Now, when you say body tremors, that's referred to in the citation. He's seated in his vehicle. So what was trembling, sir?
His fingertips.
I'm sorry?
Fingertips.
His fingertips. Okay. Now, Mr. Smith's 59 years old, right?
I reckon so.
He's not a young man, and so there could speculating there could be a lot of reasons somebody might have some trembling or tremors, couldn't there?
I agree.
Okay. And did he appear nervous?
I don't recall. I'm not around Mr. Smith to know, around him enough to know when he's nervous, when he's not nervous.
Well, it's logical that perhaps he would have been nervous when he stopped in the middle of Burkesville at 11 o'clock at night, correct?
With methamphetamine in his pocket, I would say so.
All right. I believe that's all questions I've got.
Did you say that, did he initially hand you his insurance card?
You need to speak up. a little
I'm sorry,
bit.
did he initially hand you his insurance card?
It wasn't initially, I can't recall the exact time, if it was when he gave it to me. I know as I was asking for it, and he went to the glove department, he had gave me that service receipt from Adair County. So I know it wasn't initially that he gave it to me, because we went through that first, and I told him that wasn't it. And then he kept it.
And, okay, that's all I've got.
No further questions, Your Honor.
You have another witness, you may stand down.
No, Your Honor, Commonwealth rest.
You have a
I
witness.
don't believe I want to call the defendant, Your Honor, but I really, really want to brief this case. I believe based on.
I would never prevent you from briefing the case, so inclined.
I think it's been an interesting quiz based on his testimony. I don't think based
You
upon.
can brief the case, just brief the case. Hey, you have another client, you stand down.
Got Mr. Wilson, Your Honor. What's the briefs do here?
What difference does it make?
If we're gonna advance this case, Mr. Cross will take as long as you give it.
30 will be fine, Your Honor.
30 days. Okay.
I think that's sufficient.
We'll try to get it out quicker. That's fine.
Okay, who's this client? here?
Albert Wilson.
Okay, Mr. Wilson. What we got here on Mr. Wilson?
Your Honor, we've got a little stumbling block getting Albert's case settled, and we're going to try to work through it, but we need another day.
I'll agree to one more day. Go from there.
September the 29th for negotiation and October 5th for next quarter.
Thank you, Your Honor. That does conclude my business. If I may be excused, thank the
Absolutely.
court for indulging me with my distraction.
Absolutely. If you have any more criminal matters come before the courts, anybody out there that's here on a criminal matter that hadn't been heard? Okay, well, thank you all very much. The next thing is the child support docket. We'll take a short break. Oh, we got a show cause docket. We won't take a break. Show cause docket. Kaylin Bolton. He's paid and he's caught up. Lisa Dobbs. Paid in full. Joshua Duval. $50 payment. Anthony Garrett. $100 payment. Elizabeth Scott. You hear Miss Scott? Did you make a payment?
Yes.
How much did you pay? Pick it up a little bit.
Yes, I just got off the ankle monitor, so I'll be able to pay it now.
How much you supposed to be paying? So
Okay.
you need to pay another 30%.
Okay. I will. Thank you.
Christopher Slavy. What's she supposed to be paying? Karen Spears. Issue a benchmark to Karen Spears. Okay. Child support docket. Jessica Severe versus Severe.
Judge, we're asking the court to review this one in October. We're going to need to change the payee. There's been a change of custody. We'll we'll file a motion and tender an order. We're just asking to be reviewed on October date.
Shelton versus Shelton.
Making good payments, Judge. We're asking for a review in December.
Y'all are key in the microphone there. Anderson versus Walker.
Judge, this is our motion to suspend child support and arrearage based on a change. We did confirm that there's no arrearage owed to the state, and I did ask the parties to be here in case the court wanted to inquire of them. That was at their request.
Tell me that again.
Just this is our motion to suspend child support at the request of the payee. We did confirm with the state that there's no arrearage owed to the state. I asked the parties to be here in case the court confirmed that.
Why isn't there any arrearage owed to the state? What's the deal?
She received pay tax several years ago, but that has all been paid back. She hasn't received assistance since 2013.
Okay, it's fine. Well, this has a one. This has got a payment to be made, so there's no payment to be made.
I guess we're just asking for payments, some monthly payments on the
Stop.
arrearage.
He walked out of here thinking he wasn't gonna have to pay anything. Jerry Leon Walker. Jerry Leon Walker, come on back here. It says it's being paid to the division. Charles, come on back up here. They were talking about, I don't know, let's go over this again.
He has an arrearage, Judge, in the amount of $810.81. What we're asking is to suspend future payments and let him make payments. We're asking for it to set an amount monthly
Well,
payment.
tell me what you want to set, $50 a month?
Pay $50 a month until you get that amount paid off.
Yeah,
Yes,
okay.
that's fine, Judge. Thank you.
Thank you.
Yeah, good. Yes, you're good.
Warren versus Brown.
Judge, we're asking this to be continued generally. The respondent is now living in Delaware. We're waiting a request from Pennsylvania in order to close that case. We've got to have. their
Sides
approval.
versus Cowgill.
Payments being made, asking for review December 21st.
Cooper versus Cooper.
December 21st, please, for review.
Hill versus Haywood.
Judge, we're waiting on DNA in that case. It's scheduled, so we're asking for the court to review it on the October date. He's here.
What you got the 5th day of October, be back the 5th day of October, they're reviewing the DNA.
That's it. You got that DNA. Thank you, Jason. Judge, I believe that's all the matters I had. Thank you, Judge.
Brown versus Brown. Hello.
Judge, I had filed a motion to compel and a motion for contempt against Mr. Brown. We have two orders, one that was entered in June and one that was in July, both regarding co-parenting counseling, and he has, other than his intake appointment, has not participated in any sessions. Did receive the motion from Mr. Carter. I knew he was gone, so when I mailed this, I mailed it directly to Mr. Brown as well as to Mr. Carter. We'd like to go forward with it. I think Mr. Carter filed something asking to be relieved and asking to allow Mr. Brown time to hire an attorney, so I'm not sure how the court wants to proceed.
So you're talking about the co-parenting thing? That
Yes, there are two agreed orders, and Mr. Brown agreed on the record in front of the Domestic Relations Commissioner to participate in co-parenting counseling. So it's pretty straightforward. He did do an intake appointment quite some time ago, but has had zero follow-up.
Yes, I did go one time, and I have not had a chance to go back.
When can you schedule?
I don't know. I'm asking for a continuous hire attorney.
I mean, how much time does this co-parenting thing take? How much time? One session or what?
I mean, I think that would be up to the therapist, but I mean, they've not even managed to get into a room together in front of a therapist, so it's hard to say. I mean, they would recommend the frequency, I'm sure. But I mean, you're talking about, I think at maximum of an hour a week. I can't imagine most individuals don't have at least an hour a week that they're available. And we even found a counselor in Columbia to accommodate his work so that it would be easier.
So it's an open-ended sort of, what's the underlying issue?
We've modified the time sharing temporarily and has expanded Mr. Brown's time. And because of that, parties have not traditionally had a situation where they both weighed in on parenting issues where they've communicated a lot. That just hasn't been the case. And now that this is where we are, the kids are teenagers. Based on the communications I've reviewed, there's a complete lack of ability to co-parent and to respect each other's boundaries and to communicate in a healthy way. So I have found that a little bit of time with a professional who can kind of guide them on things that might be triggers, things that are appropriate.
I'm not understanding what you're saying. Is there a disciplinary problem with the children? Two children, one child?
Two children.
What's the problem?
Judge, it's the communication between the parties.
I mean, okay, the parents don't like each other, not communicating with each other.
Sure.
What impact is it having on the children?
Well, it's affecting greatly the children. I guess my concern is the children seem to think that they're in charge of everything. And they have asked to be able to just dictate when they go where and what they're going to do, which is not appropriate. Regardless of their age, the parents still need to be making those decisions. And they're just not able to even talk to make a decision on anything together. And so it's a concern. I think that I have seen communications that are very demeaning to my client, very dismissive to my client. And I know that there have been occasions where that has been expressed in front of the children, which is very harmful. So those are things that I have found can be quickly and easily addressed. It's just something that, I mean, you're not born knowing how to co-parent in two different households. And that's just something that some people need a little help with. And I think that that's what we've got here. And like I said, the parties agreed to do this. I thought in good faith. It seemed like in good faith that day in court, but apparently not.
You got an order on it, or they just agreed?
We agreed on the record that we would do the co-parenting counseling. That was then reduced to writing in June. And then when we had a review in July, it was again put in the order that they would actively participate in co-parenting.
They signed the agreed order?
I'm sorry?
You said it was put in writing. Did they sign the agreed order?
The attorney signed the agreed order. As I said, he agreed on the record when we were with the Domestic Relations Commissioner.
What did the agreed order say?
The first, just that they would participate in co-parenting counseling. Let's see if I've got. First one. Yeah. See, the one from July 31st just says that parties shall continue to actively participate in co-parenting counseling. Both parties shall ensure that all school and extracurricular activity responsibility, I mean, it goes on to a couple of other things, but I mean, that's what it says regarding the counseling. With regards to the June order, just says the parties shall participate in co-parenting counseling with Tommy Hadley of Serenity Health in Columbia, Kentucky. And this order actually said that Ms. Hadley would both contact Ms. Hadley within 10 days to schedule and take sessions. So that was the initial order.
So you don't want to just do that? You don't want to like sign up with a co-counsel between now and then, or you
No,
don't?
sir, I do not.
Okay. So you changed your mind about it?
Yes, sir. I was not under the assumption, under the.
Okay, well,
belief
that's
that I-
all. You don't have to tell me why. You just, you didn't sign it yourself and you,
No, sir.
yeah. So you want to obtain counsel.
Yes, sir.
So what I'm going to do is reset this for it's October 5th, is that right? October 5th, and you can bring a lawyer with you then, if you can't work it out before then, okay?
Is that at
Okay.
1 o'clock as well, Judge?
Yeah, it's 1 o'clock or soon, well, it was 1:15 today, and we actually started 1:17, so. Okay, thank y'all.
Thank you,
Thank
Judge.
you. Watson versus Roach. Oh. You get the motion here, I'm good. Go ahead.
Judge, this is on the respondent's motion, was supported by an affidavit that we filed July 28th of this
You go ahead
year.
and speak up because we got a new system.
Okay, speaking about as loud as I can, I got a little sore throat problem, so that's about as loud as I can speak. Can you hear me?
If you lean toward the mic, it'll probably help.
Okay.
Yeah.
This is a motion to modify. There was an original mediation order that was entered March the 1st from 2022. That was objected to. We had a hearing in March of 2022, and we had an agreed amended mediation order that was entered finally April the 19th of 2022. And this court entered an ex parte order for emergency custody and suspension of visitation pending a hearing on September 7, 2022. The court amended that order by April 24, 2023. With a review date that's going to be, I think, May 25, 2023. There hasn't been any further amendments to that order. So where we were left with, where my client used to have an overnight every Wednesday to Thursday morning and then alternate Fridays to Sundays, 2 weeks in the summer, exchange of fall and spring break and Christmas, he was down to, he got Christmas Day, 7 hours of supervised visitation last year. And then he's got Wednesday from, I believe, 5 to 8, and then every other Saturday from 2 to 8.
So every Wednesday from 5 to 8.
Yes. And every other Saturday from 2 to 8, supervised. And that is not working out, Your Honor. Half the time, he either gets a text or a call from the mother saying either one child doesn't want to go, or one child's got a ball game, or one child's got this or that, or they got some other excuse why not to have it. And he has supported with his affidavit where he thinks that, you know, that this whole custody situation, he's been so alienated from his children that it needs to be flipped, and he needs to be the custodial parent of both children.
Judge, in response to that, I mean, I know he's argued just now about increasing the visitation and saying isn't working, but his motion also goes on to ask for him to be granted sole custody and to be considered the residential parent. And they put in the, you know, the preference in the statute of the presumption of equal timeshare. course, that's a rebuttable presumption for KRS 403-270 subsection 2 by preponderance of the evidence. And I know as long as I've been involved in this case for the last number of years, that this court has heard substantial evidence to show about the concerns that have been raised with Mr. Roach. And I don't think that it would be appropriate for these children to go to reside with him or for the court to lift those restrictions until he can demonstrate some certain things. And maybe he's the one that needs the parental evaluation, given the testimony that this court has heard. Mr. Roach coaches the games. He sees the children at the games. In fact, the last time we were here on a violation was because of his behaviors at that game around other witnesses and the children that were participating. So I don't think that Mr. Meredith's motion should be granted, Judge.
Judge, and just reply, we had I think a 5.5 hour hearing before Your Honor, I think September 22nd of 2022. Okay, we haven't received a final order determining whether or not there's sufficient basis to keep an emergency order in full force and effect and deny him custody. You know, I've asked several times for the court to review that so that something can be entered one way or the other. You know, and what Ms. Capps is referring to is a matter on a contempt situation at a DBO. And while we had a 2.5 hour hearing back in May on that, the court didn't do anything else to Mr. Roach but admonish him not to act that way in public. But this had nothing to do with his children. All he was trying to do was exacerbate the concentration that was coming from the child's mother to him in front of the children. He was all he was on the field to do was to try to watch them play a baseball game, or one of the child to play a baseball game and bring equipment there. So we don't need to rehash that. But every time we're ever before this court, we remind the mother that she's supposed to at least be abiding by this each Wednesday and every other Saturday. And if you want to go into another evidentiary hearing on what's happened since that order got entered on April 24th, you're going to find out that 2/3 of the time she comes up with an excuse not to do that. And we haven't come back to the court to try to hold her in contempt. We just want some finality where he can become the father of these 2 children without restraints being placed on him by the mother, yelling or screaming at him, saying he's not doing this or not doing that. Or I'm not going to let you talk to him on the phone. I'm not going to let you text him. You know, they don't want to come see you tonight because they got this or they got that.
Judge, in response, we would ask before you lift anything that you do speak with the children again, especially the oldest child, because she's expressed that she would like a chance to speak to the court. And, you know, as far as the communications, they're supposed to be communicating through the parent app. They've been doing that, and Mr. Roach still continues to make the derogatory comments, to not foster a good situation with his co-parent. And, you know, this is not a situation where my client is trying to withhold the children. This is a situation where these children have expressed to the court their own concerns when being in Mr. Roach's care.
Because I think only one child has been interviewed by the court before. I don't think the youngest child has ever been interviewed by the court. And, you know, I filed this on July 28th, and I haven't got any response whatsoever from Ms. Capps that she wants yet to have another opportunity to bring one or more of the children up here for the court to interview. As opposed to, and I find it interesting that she complains that my client is supposed to be derogatorily making comments in the parenting app. I haven't gotten anything from her about that, but half the time her client doesn't use the parenting app. She just calls my client, says, you know, you can do this or you can do that, or if you don't want to do this or do that, then you can't see the children. So when it's convenient for her to want him to see the children,
hearing of this. What do you say the court owes you as far as any findings or rulings? Could you tell me what date we can go back and look and get you something on?
Yeah, we were here on September the 22nd.
Well, it's kind of been my experience in this case is that every time we get to the edge of having a ruling, you do some kind of agreement that kind of stops it.
The only agreement we have reached was when they filed a motion to hold him in contempt in the DVO file. We had the hearing over in Clinton Circuit Court because it's more convenient to do it there than here. We reached an agreement to let him coach the oldest child, Saban's baseball team, so that it was an exception to the current DVO that was in place. That's the only agreement that we have reached. The court did, after several inquiries from my office as to whether we were going to get a final order from the September 22nd hearing from last year, enter a temporary order that gave him each Wednesday and every other Saturday for some limited period of time supervised. But there hasn't been anything since then.
Judge, I would ask that we do set a separate hearing date so that we can have both of the children present. They're actually in school today, so I didn't want to bring them out of school to court if we didn't know if the court was going to speak to them. And also ask that they undergo a parental evaluation assessment before the court makes any type of ruling.
Professional person?
Yes.
Do you have anybody in mind?
I do. There's an entity in Louisville, Kentucky called Shelton Forensics.
I've heard of it. And who is it she's wanting to have tested?
I would ask that both. I mean, he's making allegations. My client has asserted allegations. Have them both assessed.
You can't find anybody closer than Louisville. I mean, my client lives down in Tennessee.
Sadly, I've had to go through this issue on a few other cases, and it's been difficult to find somebody that's any closer. It's either going to be Louisville or Lexington that would meet criteria.
Somebody in Nashville.
And I can forward, I have the intake packet information with Shelton Forensics. I can forward that to Mr. Meredith. He can look over it as well.
Does my client last time, the DVL situation was sent to anger management classes and it's already taken that test. What kind of test is she now wanting to do?
Judge, he raised the issue about asking for
What kind of additional evaluation?
They do a full-blown parental assessment and psychological assessment.
How much does that cost?
They have different price categories. I think it ranges between $3,000 and $5,000. So I would ask that they split the cost.
Judge, we can't afford that.
But that's the issue, Judge, that obviously there are some problems here, and I think this.
You think? You think there's some problems here?
I think that some of the issues that we have demonstrated with our proof in the court and Mr. Roach's, frankly.
You know, they don't like each other. They can't get along with each other. They won't follow orders, you know, on and on and on. I'm going to just send me a short notice on exactly what you want me to enter to see if we can get something final and appealable.
All right.
On this thing. Do you want is there any additional testimony that you think would be helpful to the court as to what the goings on between these two and the children that you want to bring in? I'm not going to order them to pay $5,000 for an evaluation to say that they don't like each other, they can't get along. Is there any, you want some more testimony about things that have gone on since then? He's obviously saying that she's made efforts not to follow previous court orders. I'd say he probably wants some testimony on that. We've had all kinds of testimony on this.
Judge, I would just ask.
It gives me more of incentive all the time to think that there ought to be family court judge, so this couple passed from me. So, but when y'all want to set a date, I'm good.
And one other thing just to address so that it doesn't become an issue that they file motions. My client has scheduled a cruise with the children. Is it the first week of October for fall break? And so we just want to make sure on the record so that it doesn't become an issue later on that this court has to address.
What are the dates on that?
It's the week of fall break. They go, we all let my dad come back that.
Give me some dates.
So it would be October the 2nd through the 7th.
Is there any problem with that?
Is he gonna get to see him on his Wednesday? Is he gonna get a makeup Wednesday for being gone?
Yes.
Is he gonna get to see him before they go then? Cause I take it they'll get out of school on Friday, the 30th, 29th.
29th of October,
No, the
September.
30th of September
September 30th.
would be the Saturday, I think, that
Actually,
the 29th is when they get out of school.
29th would be Friday, 30th would be Saturday, and the first.
What's he normally see them?
Sees them on Wednesday and every other Saturday, and I don't know if that's.
Well, are they out of school on the 29th? Or they?
No, they go to school on the 29th.
Okay, what time on the 30th? You usually see them on the 30th?
Would that be this weekend?
Let's see if that's his normal weekend.
This Saturday would be his weekend. So the second. The 30th would be his normal weekend.
How long does he get to see them on those?
10 to 2 is what it is on every other Saturday.
What time are you leaving on the 30th?
We're leaving Sunday.
So you're not leaving Saturday?
No.
So you can see him on the 30th.
Judge, the only visitation he would be missing would be that Wednesday of that.
We'll make it up.
You just get that additional time that he would have had on Wednesday on that Saturday. He gets 6 hours on Wednesday. 3 hours, whatever it is.
It's okay. If you don't have it that way, then an extra day.
Well, I mean, he's only getting Wednesday from 5 to 8. So
What
that's.
I'm telling you is that if he wants to combine that time period.
Yeah, that's what I was
on the
thinking.
30th, it's fine.
Yeah. Just
Or if he
combine
wants
it.
the extra day, I thought he might rather see him 2 different times. It doesn't matter. What time
All
would
that time.
they be available on?
The 30th at regular time. We'll still be in town on the 30th. We'll be back that next
Yeah, well, what time is the regular time?
10 to 2 on every other
So
Saturday.
to pick up, it'd be 9 to 4. 9 to 4,
All right.
okay? And then let's pick a date for a hearing.
Judge, what does your calendar look like in the afternoon of the 7th? I have a hearing here in front of,
What?
of September. I have a hearing
No.
here. No.
It's about the only time I can do it. What about the 13th?
I have juvenile court that
So it's
afternoon.
not good.
And just to be candid with the court, I'm handling all the transfer hearings with the
No,
white.
I don't care. I mean, if you're not available, you're not available. What about the 12th?
Both of September.
Yeah.
I've got juvenile court in both in
Okay.
Circuit and Allen County as well.
Okay.
I've got circuit and there.
I could do the 14th or the
It's
15th.
quite a motion day.
Okay. Do the 20th.
Megan, is the Bricker trial off on the 19th and 20th? We continue it today.
I can do the 20th.
Okay. Let's see what I got.
I've got that afternoon. I have juvenile court, but I could probably do it that morning.
The morning of the 20th.
Yeah. I can do it.
That's 9 o'clock.
I just have to be in Columbia at 1. Just
Believe me, you're gonna be in Columbia.
Okay, just making
I
sure.
can't guarantee you'll be there, but it won't be because of me. So that's the 12th?
September the 20th.
It's a Wednesday.
Yeah, it's a Wednesday, okay. You can't have it. Okay. All right. And I want y'all to be all encompassed. encompassing on this. Anything that's happening that should impact my final ruling.
Good, Judge.
Okay, thank you. Jamel Seams Reasonable versus Sheila Willis.
It's on my motion for default. Defendant's been served, services in the record. And
What is this? I saw your motion and everything, but I didn't have a file. What is this case about?
Judge, she was overpaid, mistakenly overpaid about $8,000 worth of wages after she was terminated. She didn't get out of the pay system. And so we'd asked her to repay that money. She has refused.
Okay. Okay, I'll sign the order. You submitted an order, right?
Yes, sir.
I'll sign the order. Okay.
Have a great day.
Thank you.
Thank you.
Accelerated inventory management versus Cusino. Continue to October 5th. Miller versus Huckabee.
So this is our motion for essentially some visitation. I've styled it for temporary joint custody and equal time sharing. But essentially what we're asking for is some temporary visitation to get us through until we can get in front of the board for a hearing on this matter. These parties get along pretty well. He's visited with the child.
How old is the child?
Child's 6 months old.
And she's breastfeeding, Your Honor.
He's visited with the child.
What do you want?
He's off Monday, Tuesday, Wednesday, and Thursday. We're just asking for a couple of days a week.
Whole days? What do you want here? I mean, tell me what. She's breastfeeding. How often is the child food?
Every 4 hours.
Okay, so we could do like some several 3 hour days or something like that.
Yes.
Yeah, if we could do three 3 hour days a week, that'd be great to get us tied over.
And Judge, we had previously sent, he had indicated he wanted Mr. Judd to review it. We had previously sent him a schedule for him to do Mondays, Wednesdays, and Thursdays, 6 to 8. So we could modify that to 5 to 8 if he would be willing to do those
5 in the
days.
morning?
No, 5 p.m.
Judge, he just wants some time.
I understand what he wants.
Yeah,
I'm just trying to work through it here. Okay.
I think 8's a little late for
I
a
think
6
it
month
is
old,
too.
but
Let's do 5. Let's do 5 to 7. But do 3 days a week. Where's this gonna be? Where's this visitation? gonna take place?
visitation will be at his house, Judge.
How's the child gonna get there?
He can.
Do you have a child seat?
Yes, sir.
Okay. Are you satisfied with the child seat that he has?
I don't know what kind he has, but he can use the one I've got.
Well,
I also have the base for that seat that she has.
So you gotta, so I would tell you, I'd like for, just out there, so everybody's kosher with it, as they say, just let her look at the base to make sure she's satisfied with it.
That's fine, Judge.
Is that all right with you? And you do 2 hours, 3 days a week, till you get, till it's on by. Now, have you had any experience with children at that age?
No, sir, I haven't, but I would still like to be the father that I can.
Oh, well, I'm not criticizing you. I mean, you can't have any experience with it because it hadn't been around.
Yeah.
But where are you gonna visit with the child at? Your parents or something?
Yes, sir. Yes, sir.
Well, I would just say that, just out of an abundance of caution, that it would be good if you took the child somewhere with somebody till you get your sea legs, if you understand what I'm saying. You know what I mean?
Yes, sir. My parents, they're my neighbors. They live right next to
That'd be
me.
good. That'd be good. So the visitation will take care of your place and your parents will be available, right?
Sir.
Yes, sir.
Okay, let's put that in thing.
Would Monday, Wednesday, Thursday be okay? He can't do Friday, Saturday, or Sunday.
Yeah, we had posed Monday, Wednesday, and Thursday
Y'all
before.
get me a great order on that, we'll do it.
Judge, could we just ask that the visitation take place at his parents' residence? Just,
No, it's not necessary. They're not, if they're right, what is next door from here to where?
Like 20 feet.
That's it. It's all right, you know, I don't think there's anything wrong with your mother being present during those time periods. That'd be good, you know. Your father might be a great baby person, I don't know, but
Sorry.
just taking a.
Sure.
Okay.
We'll get you an order, Judge.
Okay, thank you.
Thank you, Judge.
Thank you,
sir.
then might be just doing us work in the Lord's office running.
Okay, we have a EPO, a couple of EPOs in 10 minutes. Start at 2 o'clock. Take a big break here. 10-minute break.
Judge, we also have about 15 to 20 jurors coming in for that orientation at 2 as well, whichever one you want to do first.
So they're not here yet, are they?
Well, I think they're in the lobby, some of them. I've seen some of them.
People that didn't show up?
Yes, sir, the ones that were excused from the first orientation.
Show up, okay, we'll do that. Oh. We all.